may be permitted to mention a matter in meter. Item number 52 million. Okay, petitioner does not want to proceed this matter.
Item number
52 million.
52.
It is also
You just wait, let it call. Let I call the matter.
does not want to proceed this matter, Miller.
You are the
Petitioner, Miller. Advert and record. Later is it.
However, let it be called. You just wait. Item number 52.
52 Miller.
You just wait, I will call the matter. Call the list.
Item number 1.
Apurva Kanchan Devray versus State of West Bengal. In deciding the matter, I have framed two issues. First issue is whether the order of disciplinary authority is perfunctory, purposive, and in violation of the natural justice. Second issue is whether the award of punishment is disproportionate. I am reading only the operative portion of the judgment. It appears to me that the Honorable Supreme Court has framed specific guideline where a disciplinary proceeding can be come under the judicial review by the High Court under Article 226 of the Constitution of India. Following the observation of Honorable Supreme Court in P. Gunasekaran, I am of view that the evidence which was laid before the disciplinary authority cannot be reappreciated by this court on the ground that the evidence could be construed otherwise. Furthermore, the interference with the conclusion of the inquiring authority, if it appears that was passed after giving reasonable opportunity of being heard to the petitioner, the same cannot be declared to be perverse. This court also cannot go into the adequacy of evidence or reliability of the evidences. It appears that inquiry was held by the competent authority according to the prescribed procedure in that behalf. I find that there is no violation of principle of natural justice in conducting the procedure. Moreover, the authority concerned, after hearing the petitioner, has come to the conclusion. It further appears to me that the correctness of the order of the authority concerned cannot be looked into by this court as a second appellate authority. In this particular case, 58 PMLs were allowed to be credited at the account of the borrowers without verifying the KYC documents. Huge amount of public money was flown down while the petitioners, being a responsible bank officer, failed to provide required vigilance before sanctioning the loans. It is surprising to note that how 58 numbers of agriculture loans, 1 lakh each, were sanctioned without verifying any KYC document. Due to non-verification of the KYC document, the bank failed to recover those monies, which resulted a burden upon the general creditors of the bank. Considering the circumstances, I find the punishment as imposed upon the petitioner is not at all vindictive or unduly harsh. Thus, it is not disproportionate to the offence as to shock the conscience of this court. The argument as advanced by the learned counsel for the petitioner regarding non-presence of perpetration of fraud, whether proved or not, it is not to be looked into a disciplinary proceeding. Rather, it may warrant a criminal proceeding. Under the above observation, I find no jurisdiction or justification to interfere with the order of the disciplinary authority as well as the appellate authority and reviewing authority of the present respondent bank against the petitioner. Thus, the instant writ petition being meritless is hereby disposed of. Call next matter.
Well, in this matter, for the petitioner, on last occasion, state submitted a report. Now, my exception is ready, but could not be affirmed as the petitioner could not come. He is from Purulia. In this week, it will be affirmed. So, Lordship, kindly take it on next month.
Not this week.
So I'm for the petition item number 8. It's a matter already disposed of.
Judgment was passed on 27th of November, Your Lordship.
Okay. Please take down.
Lordship, subject to that, there is a small correction to be
Made.
made for the judgment, Your Lordship. The name of the advocate for the petitioner has been misspelled, Your Lordship. If that would be corrected,
Name of the?
advocate for the petitioner.
Yes. What name?
Now it's written Nabeda Akbar. It's supposed to be Nabila Akbar. That is me.
Yes. What is the spelling?
Nabella.
Give me the letter. Write it down and give it. This matter appears for correction.
For the partition,
Yes. The name of the learned advocate appearing in the first page on behalf of the petitioner should be correctly written as instead of Mr. Nabeda Akbar. Mr. Nabeda instead of Mr. Nabeda last number. Last name. The date of judgment was also wrongly noted as 17/11/2024. It should be read as 28/11/2024. Huh? 28. Okay.
And Lordship, name of the advocate record Mr. Himadri Roy. That was not recorded in the order. May I?
Name of the advocate
Advocate on record Mr. Himadri Roy
for the petitioner.
for the petitioner was not recorded.
Mr. Deobroto Sahara, senior
Lordship.
advocate, Sayyadi Huda,
Ah,
Mr. Sheikh Aftauddin,
Lordship.
and Mrs.
Nabila Akbar
Nabila
and
Akbar.
Lordship Himadri Roy. That name was not recorded.
Give me the name.
Lordship.
Next para, the latter portion and latter submission of the learned counsel for the private respondent was also not noted in the judgment. It should be noted here under. Remaining portion of the judgment should be unaltered.
Obliged, Lordship.
It's for the extension of interim order. The declaration of vacancy of Petition, I have challenged the same matter. The exception that you tried to
Till 30th November. Please take down. This matter appears under the heading of extension of interim order. It appears that the interim order was extended lastly on 30th of September 2024. Extended till 30th of November 2024. Full stop. The matter is not ready for hearing. So petitioner prayed for extension of interim order. Having heard the learned counsel for the petitioner, also considering the matter, status of the matter, I think it necessary to pass an interim order, to extend the interim order. Let the interim order passed by this court on the earlier occasion is further extended till
Can extend till disposal of the appeal of pending before the Honorable Division Bench and let the matter be placed out.
why?
But this
Let
is
it
with regard
appear
to
on
declaration
7th of
vacancy.
January.
This is with regard to declaration of vacancy, which I have challenged the vacancy declaration notice. I am an existing dealer. Same issue is pending before the Honorable Division Bench.
Same.
Same, sir. I have challenged the vacancy declaration notice.
Okay. Till the disposal of the further extended till the disposal of the appeal pending before the learned division bench in MAT 1543 of 2020 or until further order whichever is earlier. Let the matter go out of the list. Next,
For the petitioner, I am paying 7 days time to give reply. They have served the opposition. So kindly let it be 10.
you received the opposition?
Yes, yes. Day before yesterday.
Okay, let
Let it retain in same position, my lord. And we shall give replies by 10th. They serve as the opposition.
Where is the affidavit?
Because file,
We have
You file it in the course of the day.
and the records, I file it immediately. File.
it will be on 10th on the same position. Not matter.
Learned counsel appearing on behalf of the petitioner submits that he received the affidavit in opposition on behalf of the
Respondents.
state respondent. Full stop. Learned counsel further submits that he intends to use reply against the affidavit in opposition. Considering the submission, the petitioner is at leave to file the reply within a week.
By 10th.
Within a week,
Yes, sir.
let the matter appear in the list on
10th.
10th of December. Full stop.
And retain the same position, my lord.
The affidavit in opposition filed on behalf of the respondent number 1 to 5 is taken on record.
But the matter will retain the same position.
Yes, yes, under the same position.
The same position. Careful.
Then I
For
open
the
for
petitioner
state.
lordship, praying for extension of interim order.
Interim order expired.
Expired.
Expired on 30th of November.
Mention prior that.
Yes, your lordship.
Okay, very well.
But in the order, I should point out, there's a small mistake. Not with regard to the interim order or the extension thereof. I'm not on that. But if your lordship kindly takes, the paragraph in the first page earlier, the paragraph earlier, the bottom of the first page,
You are mentioning the order number, order dated.
order dated 3rd October 2024.
Okay.
Kindly take, the first page bottom, which is earlier the honorable coordinate benches. Got it,
Yes.
in various writ petitions have held that such declaration of vacancy not in conformity with law. But Justice Patnaik had held that it is in conformity with law.
Yes, yes,
Thereafter, the petitioners had challenged.
yes.
So, this submission may be recorded. Otherwise, only difficulty is that if someone uses this order in a next matter, saying that similar interim orders have been passed, there may be some other advocate who will not be aware, and this mistake will be perpetuated.
I understand. I understand. Okay, please take down. This matter appears under the heading of extension of interim order. Learned counsel appearing on behalf of the petitioner submits that The interim order was lastly extended till 30th of November 2024. The matter is not ready for hearing, so the interim order passed by this court may be extended till a further period. Full stop. Learned counsel appear, Mr. Shishana Mondabhatay, learned standing counsel, learned junior standing counsel appearing on behalf of the state authority submits that authority raised strong objection against the extension of interim order. Full stop. Mr. Bandyopadhyay further submits that in the order dated 3rd of October 2024, at the last paragraph of the first page, this court has noted down that one coordinated bench in various writ petition has held that vacancy held that such declaration of vacancy not to be in conformity with law. Full stop. The state of affairs, full stop, the state of affairs is not correct as written in the order itself. Full stop. He submits that actually the coordinate bench of this case, coordinate bench of this court in various writ petitions has held that the declaration of vacancy is conformity with the control order 2013. Full stop. Let the submission made by the learned junior standing counsel be noted herein. Full stop. Having heard the learned counsel for the petitioner, I think it necessary to extend the interim order. Let the interim order passed by this court on the earlier occasion is further extended till 7th of January 2024 or until further order whichever is earlier.
The state may file a report in the meantime. There is no direction in the earlier order.
There is no direction?
But since the lodge was recorded, that matter is not ready for hearing.
Hmm.
That direction may remain other.
Okay. The state is directed to, no, state is a leave to file a report in the form of affidavit in this matter within 2 weeks after vacation.
But in case the state files a report, may be allowed to file exception.
Okay. Exception, if any, by the petitioner within 2 weeks thereafter. Next.
Obliged.
Next.
Milord, I think 13 was disposed of by a lordship. This was the appeal of insurance company.
Okay,
Your
that review application.
Lordship, Milord,
I have been told, sir.
Milord, no, Suparo. Milord, I was informed by Miss Ghosh, Milord, who filed the review application. Mr. Punik had appeared.
Yes.
Milord, she would not be pressing for it. Milord, right now she is not here. My learned friend is paying adjournment on her behalf. But Milord, I'm just informing a lordship, Milord, so that Milord, next time if I'm not here, lordship will kindly Milord dispose it off.
Okay.
But lordship kindly Milord not pass any order. Let them.
I'm not
let both,
passing any order.
because both confronting parties, Milord, Mr. Imam Ali Shah and Miss Ghosh, they are not here right now.
Hmm.
Lordship,
So-
kindly pass it over me, Milord, whenever they comes in, if they get an
Next
opportunity.
Next week, how much is it?
Is it possible to settle down in the next week?
Yes, Milord, she said that she won't be proceeding with this. You also kindly pass it to her. If in case they comes in, Milord, I'll inform them to approach your lordship and pray before your lordship for disposal of this
Okay.
or dismissal of this application.
Okay, pass it over
Pass
now.
it over.
Okay.
Grateful to me. I'll inform them.
Okay.
God bless you.
13, 14, 15. Next.
Item number 16.
Next,
17.
next,
18. 8. I have challenged the vacancy notice, and on last auction, my lord was pleased to direct to the state advocate to furnish a report. That report has not yet been furnished or even served to me.
what report? What report?
Report regarding during the subsistence of one vacancy without conclusion of the selection
Okay,
in
okay, okay.
respect of the earlier vacancy again is-
Without cancellation of earlier
Yes.
vacancy, it
And
was again,
there is an order of this court to conclude the selection process within time.
Very good.
Petitioner himself filed this petition on earlier occasion. This is second round of litigation.
come on next week then? Not this week.
It's at Wednesday, my lord, because Monday, next week, Monday, I have some personal difficulty.
Wednesday,
Wednesday,
Wednesday. Okay. 11th. 11th of December. Note it down. 11th of December. Next. Next.
My lord, in item number 20, I am appealing for the petitioner. The state authorities were supposed to file a report. My lord, see, no one is appealing for the respondent.
Mrs. Sonal Sinha. Amritalal Chatterjee.
The order was passed in October 2024. They were supposed to file report within 2 weeks. Yeah, have not been served with any copy of the report.
No declaration is there.
Nothing. No report has been served to us.
What is your prayer in the writ
My
petition?
lord, if I may point out the facts in a nutshell.
I understand there are no such MR shop
My lord,
in the locality.
the MR shop which was there, that shop surrendered, because of which a vacancy arose, and they were supposed to open the fair price shop in the same locality where it will be convenient for all the customers to take and collect, to go there and collect the goods. Instead of opening there, they are opening the fair price shop somewhere 2 to 3 kilometers away, where in order to visit that shop, we need to cross the highway intersection. It is not possible for the elderly person or the children to go and collect the goods. That's why I had filed this petition. Now they were supposed to come back with a report. They have not served us it.
Mr. Chatterjee is here.
So what is it?
Yes, madam. Only a simple writ petition is filed here with innocuous prayer.
The innocuous prayer, my lord, let the shop be opened in our locality so that it will be convenient for all the customers, not only me, for all the customers to go and collect the goods.
You have submitted one representation, I think.
I will just-
Joint representation.
My lord, joint representation. Yes, I have
Yes, let the representation be disposed. Annexure P4.
My lord, yes, page number 19.
Annexure P4.
My lord, mean My lord, it starts in P4. It is a notification. My lord, only one humble prayer. Meanwhile, they have declared a vacancy in some other place in respect of that particular locality, which is 2 kilometers away, and we need to cross the highway. In respect of that notification, no shop be opened. Otherwise, it will be great inconvenience for us.
Now you are the inhabitants of where?
My lord, I am the inhabitant of Kaliaganj, Nodia. My lord, if my lord sees the post title, Devogram, Nodia. My lord, if my lord sees page number 17, page number 17.
No,
of the
this rate petition is not filed on a representative capacity. Only you singly file this rate.
Singly filed. My lord, if my lord sees page number 17, in page number 17, serial number 12.
Yes.
Page number 17, serial number 12, my lord, initially the FPA shop, fair price shop was in this locality. In this locality and where we used to reside. My lord, the
Village Devogram, Kaliganj.
PS Devogram, Kaliaganj, Kulaichundi, Puraton Bazar, Piccadilly Cinema Hall এর কাছে পঞ্চায়েত দেবগ্রাম থানা কালিয়াগঞ্জ জেলা নদিয়া. My lord, initially the APS shop was located in this locality. We used to go and collect the goods from this place. My lord, then the dealer surrendered. My lord, they were supposed to open this in this vicinity within this locality. My lord, what they did, they initially published this notification for opening a shop here. This notification says that the shop should be opened in this locality.
Yes.
Subsequently, if my lord takes up page number 18, my lord, subsequently they amended it. My lord, if my lord sees the first paragraph, it is hereby brought to the notice of all the concerned state government by notification such and such. Denotification has been announced for 6 places. My lord, if sees page, serial number 6 of this notification in the table, my lord. This is a different place. My lord, is 1.5 or around 2 kilometers away.
This is Devogram near Piccadilly Cinema Hall, Kaliganj.
My lord, this is not Puraton Bazar, my lord. Maybe other names are there, but it's not near the Puraton Bazar. My lord, if my lord sees serial number 12, it says Puraton Bazar.
What is the difference of
My
Puraton
lord, the
Bazar?
difference is 2 kilometers. And difference between these
No,
two
near
places,
Piccadilly Cinema Hall. This is the cited location.
my lord, that's the locality, that's the landmark, but the distance between two places is 2 kilometers. We decide there. We have seen it physically. My lord, the distance between the place is 2 kilometers, and we have to cross the highway intersection.
Then the report is required. Otherwise, then report is required.
Because my lord, the landmarks consider my lord, landmark is concerned. That is a landmark.
Piccadilly Cinema Hall. This is
My lord, that if you
But it is not in the Puraton Bazar. My lord,
if the landmark is the center, my lord, it will be periphery in my lord the radius. That is radius.
Otherwise, it
My lord,
here
is well
facing
aware that
difficulty. If we had to cross the highway intersection and go and collect my
my lord, this concept is goes. There's a duare ration is there, my lord.
okay, you submit a report.
Lords.
my lord, let a peremptory direction be passed that it should be filed and served with it.
Yes, Mr. Chatterjee.
Lords welcome. 2 weeks, my lord.
Mr. Chatterjee is I don't know what he's doing. I'll have to call him up very frequently then.
Very well. Please check that. Report in the form. Okay. Mr. Amrutala Chatterjee, Learned Counsel. No, Mrs. Sonal Sinha
ঠিক আছে
with Mr. Amrutala Chatterjee. Learned counsels appearing on behalf of the state authority submits that to decide the issue,
My lord, I read
report,
by Mr. Sinha.
consolidated report of the authority is required to be filed. Such report is not ready. So we prayed for some accommodation.
My lord, I led by Miss Sinha, my lord.
Yes, yes, I have noted it down.
My senior.
Learned counsel for the petitioner submits that let a peremptory direction be passed to the authority to submit a report. Let the matter stop. Having heard the learned counsel for the party, let the matter appear in the list on 11th, possible?
My lord, these weeks I have some personal difficulty. Keep it after 13, my lord.
Then on 23rd,
Lordship.
23rd of December.
Grateful, my lord. My lord is not available.
My lord,
23rd.
meanwhile,
Advance
was
process.
cleared, my
No,
lord.
no, I am opposing, my lord.
What?
If my lord sees my prayer D in the writ petition, I am humbly seeking for an interim order of injunction restraining the respondent from opening the APA shop in the new place meanwhile.
Let
Until
the
unless
report
they-
be submit
Let
2
me,
weeks. What to be done? 2 weeks.
And
My lord.
for these many days, nothing has been done. What
First
now?
of all, his
that
locals
even-
have,
that
he has
even-
to,
that even the order in terms of prayer B pass, prayer
My
D
lord,
be passed. My lord.
first of all, he has to
No.
satisfy his locals also, na?
Yes.
Because Lucas, I am a consumer.
Consumer
I am a
locals হবে?
consumer.
Consumer
Okay, okay.
28টা দেখবে আমি
If
10
my
নম্বরে,
learned
হ্যাঁ?
friend is
Every
willing
consumer will
to
come and
willing
pay
to
my
argue on
petition,
the
Lord
point of
Jesus.
maintainability, I am
Come on that day. Come on that day.
My lord, I'm sorry, but the board collapsed. In item 17, my lord, there was a confusion about your lordship's determination. My lord, yesterday, if your lordship recalls. Lord, may I just try and clarify that? Because if there's no determination, then we'll move the alternative bench because, my lord, we need relief in the matter.
Yes.
If your lordship can just
Give me the
consider, my lord,
papers. আছে ব্যাপারটা?
item 17.
Item 17 টা দিন তো। I called it.
I'm sorry, my lord, the board collapsed, which is why, my lord,
Board collapsed.
that's what, my lord, I'm being informed that after item 1, 2 to 19 was very swift.
No, it was swift, I think. I know.
So, my lord, we should have, my lord, been vigilant.
Yes, what is the rate about?
My lord, my import-export license has been cancelled. Under the Foreign Trade Act, under the Foreign Trade Development Act of 1992, any person who's an importer exporter needs a license.
Now, what is my determination?
So, my lord, your lordship's determination is Group 8.
Yes.
My lord, under the writ rules, if your lordship will see Group 8, it says matters relating to regulation of industries and essential commodities
Yes.
and various central orders
Yes.
may be divided under the following subheads. First is grant, cancellation, suspension of license. So this is, my lord, a license issued by, my lord, a central authority, namely the DGFT, who's a central
No,
authority.
all license not come under my determination.
No, central
No,
license.
central act under the Essential Commodities Act only. I don't have determination to other central acts like that. Otherwise, all determination will come to me.
But, my lord, regulation of industries. It says regulation of industries and
Yes,
essential.
regulation of industries in respect of essential commodities. Coal, oil, these are the essential commodities which come under this jurisdiction.
Very well, my lord. I have no preference between courts. If your lordship is of the view that it may be taken up by because it's filed as a Group 8
What is
matter.
the department? Customs?
My lord, no. This is, my lord, the DGFT.
DGM?
Yes.
DGM?
DGFT.
DGFT?
The Director General of Foreign Trade.
Foreign Trade?
Yes. Deputy Director General of Foreign Trade, Additional Director General of Foreign Trade, Director General of Foreign Trade, and the Union of India Ministry of Commerce and Industry. So, my lord, the DGFT is an authority, my lord, under the Ministry of Commerce and Industry. Now, since your lordship has the assignment, my
Mr.
lord,
Chakraborty, is it a group 5? Group 9? I think it is group 9 or group 9.
because we filed it as a Group 8 matter, no difficulty, my lord, may just
Yes.
clarify.
Only I have essential commodities. Only oil, coal.
My lord, we have no difficulty. Your lordship may just clarify and give us leave to approach the
Yes.
appropriate bench.
আগে অর্ডার করেছিলাম সেদিন কেটে দিয়েছো তুমি নাও নি এটা the instant writ petition appears to be out of the determination of this court. Let the matter be released for want of determination. Petitioner, to approach the appropriate bench for desired relief. For desired relief.
My lord, your lordship may want to kindly observe that that it appears to be a group 9 matter.
No, no,
because-
no, that cannot be observed like that.
Wait. I'm grateful, my lord.
Okay.
Oh, every week, sir.
I'm for the respondent. Welcome.
Yes.
My lord, I'm for the petitioner. My lord, it is that case wherein 3 times the local government demolished my godown, and that's why it was delayed. Subsequently, it was moved before my lord, and my lord was pleased to direct to reconsider the same if the godown is constructed. Now, my lord, godown has been constructed, everything has been complete except only boundary that has not been filled, could not be filled because this area is Durgam Khetro distribution of LPG, wherein it is very difficult at this time to have earth even to fill up that. That is only the trouble. All other has been completed. As it is rainy season, my lord, now no dry land is found to take earth to fill up that portion. And my lord, another ground they have shown that there is no showroom. My lord, showroom is not required as per brochure for Durgam Khetro LPG dealership. As
No,
per
this is
brochure,
a press writ, I think.
yes, yes. My lord's order was they, in spite of the order, in my lord's order, my lord, there was in operative part only the direction
Refer me
was
the
that
page.
order. This is an answer complete. Okay. One, 124, one page may be missing, that's why another copy is given. The first order of my lord. Four. And the operating part is 3 last part.
Yes. So why you here now?
Not only kindly come to page 129 of the uh, copy of the report on the basis of which again they have rejected my prayer to reconsider. Page 129, my lord. 6 reason has been shown. Boundary wall is under construction. It has been completed. Go down storage is found to be constructed with diameter. Go down storage is complete. However, mastic flooring and double layered brass wire is yet to be completed. And space between the go down and outer boundary is filled with water. My lord, the area is Durgam, the total, that's within Sundarban area, and now it is difficult to have even a. That's why it will take at least. It is rainy season is going on, my lord, only for that reason. They will take 15 to 20 days to fill up that. Only soon they will have earth, they will fill it up. And that is the only. Number 6, showroom showroom is not required for Durgam Khetro as per procedure. As per procedure, showroom is not required. Only now, only one thing is actually left, that is the area between boundary wall and go down, that area to be filled up with earth. But now it is difficult to have earth because the rainy season is going on. This area is also really Durgam Khetro.
No, you have said in the writ petition, earlier writ petition, that everything is complete.
Everything as per
Everything
bylaws
is
order
complete.
is
Everything
complete.
according to the law, you have done everything.
Everything has
Since
been
2017, it is pending, sir.
May I substantiate, my lord, what they are submitting is not correct, perhaps. The photographs of the date of inspection reveals that approach road, nothing
Yes,
done. Just
no,
leave
no,
the,
approach-
no, please. These are the photographs in your presence. On that particular day, no approach road.
no,
Under construction, photographs,
pending.
successive, that was pending on the date of inspection. My lord, kindly see, the order was passed on 25th of June.
Yes.
They were notified, they notified us on 5th of July. Thereafter, inspection was conducted on 17th of July and 19th of July.
19th.
All these periods, throughout this period, they contended before this court on successive occasion that they have completed intact.
Everything.
Everything.
Cannot be-
Now the approach road, please. Approach road, thereafter, the Lord say one by one. 13 photographs are there, my lord. Nothing has been done.
No,
Nothing has been done.
Rainy season is going.
Rainy season does not
The
prevent you
area
from.
is extremely Durgam area.
Now, another plea, rainy season. Now, what was the ground for earlier periods?
Earlier,
All 12 months was not
No,
the
no,
rainy
it
season.
was, go down, everything was completed, but 3 times the
Kindly
local
see the
code
photographs, nothing has been done.
destroyed it.
How much
3 times.
time should I give? If that is the practice, then I will have to allow
No,
such,
not that.
such relaxation to other candidates also. It would be an incident
here-
or the precedent. This
Done
cannot be
everything
tolerated,
almost,
my lord.
Malad.
We have given
Only-
ample
only-
ground.
Maximum 20 days will
Again, 20 days.
will require to
No.
complete this.
My lord, I have strong
between
objection,
outer
my lord. I
portion
have
and
specific
boundary wall
instruction.
to fill up because the
are
earth
not
is
willing.
now very scarce to have to fill it up.
No, it appears from the photograph that you have started the construction on that day also. Only on that day.
Nothing has been done.
Rainy season is since long going on. That's why.
That cannot be done, sir.
My lord, actually, it's a
I have
very
passed the order in June.
yes, my lord.
And on the basis
the-
that
all
have
the
not
date-
Kindly only 20 days time that will
No,
complete.
it is
Only
not
20 days
possible
time
to
so that land
give
filling
you
only.
permission to run such a valuable thing.
Most importantly, this will be a
My
precedent.
lord, prior to that,
In every
Three
occasion, the
My lord,
parties will come
this
and
Yes.
ask for
No.
extension of time,
Sir.
and your lordship will be bound by your lordships.
My lord,
have to allow.
my lord,
That
earlier,
cannot be the practice.
since long he completed everything, but 3 times the local person demolished his go
That
down
was-
and he sustained a heavy loss, my lord.
That was decided in
No,
the earlier writ petition.
How can I decide this issue now? That was I have already considered your issue.
Yes, my lord.
But
only
I
so
given you only, you have said that everything is complete. That's why I am passed the order. Go inspect the matter. Inspected
Yes,
after
everything
1
means-
month.
means other licenses, my
IOCL
lord, all are complete.
IOCL was directed to reconsider, and
Yes,
they have
sir, all the-
reconsidered. Ample opportunity
My lord,
was
environment, PESO and all other licenses have
That
been
was-
completed. That also took a long time. That
That's-
is, all are complete.
That I have already noted. But
Yeah.
you are not ready with your showroom.
Showroom is
Not
not
only
Some of
required.
the
not only showroom, go down itself.
go down itself is
Approach
not
road.
ready.
My lord,
They will-
showroom is not required for
Very well.
Durgam Khetro. ওইটা করুন।
Approach road has to be,
Huh?
otherwise how will be the
Showroom
loading
is not
unloading?
required. In this case, showroom is not required.
That
No,
is
your
required.
approach road is not ready, I think.
My lord, store is ready.
Kacha road.
My lord, as per their
Absolutely,
report,
Kacha.
store is ready.
Building is under construction. Photographs
Go
will
down
reveal
is
that.
ready, my lord. As per their report, go down is ready.
No.
Yes, yes.
Complete.
They have not said that your go down is ready.
But
Go down
Down
storage
storage area is
found
constructed,
to be constructed with
not
dimension.
kindly see go down storage area is constructed.
Found to be constructed.
Mosaic,
Already
mastic
constructed.
flooring is yet to be done. Flooring has not been constructed. Double layer wear mesh yet to be done. All these are required.
No, no.
Well, he has sustained a heavy loss only these.
That for which you can
20 days
get
time.
compensation. That you can claim
You are
compensation.
very reluctant.
Only
By
for the
that
cause of
way you cannot
state,
approach
state-
this court.
well,
No,
state Pradhan and others, they from beginning they were trying.
take
They
up the
tried.
cause
other
against
issues.
those.
These are the other issues not to be decided by this court.
You can agitate that particular issue.
No, no, only
Another
the
issue
last
about in
time
this.
I pray for 20 days maximum, that will be able to.
You
cure.
can pray it before them, but I find no justification to maintain the instant writ petition. How can I allow you? I have allowed you only on your submission that the matter is ready. I allowed you. Being
May
a
not
senior
sometimes-
counsel, I allowed you.
May not they are trying to find fault in any way to reject me. Only number 6 kindly the report on which as it happened.
Forget
Forum
about
was-
6. Why not the matter is ready? I have taken your understanding, your
My lord was
submission
pleased.
that it is ready.
My lord was pleased to direct.
Only on the basis of your word, I have allowed the writ petition.
My lord, and we have completed the go down also.
Not completed.
that
No,
was-
this is not the say to be.
Some, my lord, some tippling points they are raising to only intention to reject me.
How?
That is the only.
All these are insignificant.
Your go down is not ready, sir.
Go down is complete. They are, as per their report.
No, no.
Yes, yes. Kindly come to serial number 2 of the rejection order at page 129. That only due to rainy season could not be done. The whole area.
This is the
submerged
picture.
underwater.
This is the picture.
Yes, yes. At that time,
How can you contend that they go down is
my
complete?
lord, an extraordinary situation remains there during Sundarban area, my lord.
Extraordinary
That's
situation.
it.
All
Durgam- That's why its name is Durgam Khetriyo.
You
they have
approach,
applied for the
you
discussion.
approach the authority, I
fully well.
find no justification to entertain the writ petition.
My lord, this special, the circumstance of the area to be considered, my lord, kindly.
I have already considered it. Already considered it on the earlier writ petition.
Presentation, the order was passed for
My
reconsideration.
lord, last
Yes.
maximum 3 weeks time, that will be able to complete the.
This is not the prerogative writ.
My lord, sometimes they are trying to find out some fault which are not actually have no.
It's not fault, it's your submission, sir.
Submission go down was completed and it's still.
But this court has understood that the go down showroom, everything, go down showroom, approach road.
Showroom is not required.
Approach road is not ready.
My lord, as per Rosio's
And if you saying so, that the area is like that, the approaches
yes.
cannot be ready, so your go down cannot be approached by the truck.
my lord, showroom is not required.
No, your go down.
Go down is complete.
No, no, go down, approach road is not ready.
Approach road is also, my lord, at that time it was pending under
No, no,
construction. But
then-
now it has been completed.
Then how can it be completed now?
এই তো approach road এর picture আপনি দেখুন না
At that
why you are
time,
making such
now after a
Say,
long
at
time,
that time it was the date you have contended that everything was complete for which the inspection was conducted. You have submitted
Well,
before the
if-
court.
Okay, hard,
well, the area is actually really
very hard. Okay, hard. Please take down.
এটা তো হয়েছে তো আপনারা করলেন না কেন?
In the earlier writ petition being WPA number 19403 of 2022, this court has acted upon the submission of the learned counsel for the petitioner that the construction of godown has already been completed. Thus, the authority concerned is directed to inspect the godown, and if it appears to the authority that the godown has properly constructed according to the rules, the IOCL is directed to reconsider the proposal of the petitioner for issuance of letter of intent in his favor. Letter of intent in his favor. Now the petitioner has approached this court again by this writ petition containing inter alia that after inspection, some minor points of objection has been raised by the authority concerned and again rejected his proposal for issuance of letter of intent. I have perused the inspection report dated 22nd of July 2024. The report contained following observations. Page 129. देखो mark portion. It appears from the report that boundary wall is under construction. The approach road construction is pending. Full stop. It appears that the submission made before this court on the earlier occasion to the fact that the construction of godown has complete appears to me incorrect. At this juncture, I find no justification to award further time to the petitioner for completion of the construction of the godown. I make it clear that on the earlier occasion, the writ petition being 19403 of 2022 was disposed of on the basis of erroneous submission. Thus, again, the submission on behalf of the petitioner cannot be construed to dispose of the writ petition in favor of the petitioner. Under the above observation, I find no justification to entertain the petitioner at this stage. Disposed of.
My lord, as a last chance, if
No, sir.
only because he has sustained a heavy economic loss also.
I understand. How can I
As
do?
a last chance, 3 weeks time only I prayed
Yes, sir.
so that I can approach the authority after completion of all these things.
That's it.
Yes,
Item number 13, 14, 15.
pass
And
it over.
Lordship, I withdraw the petition, review petition already out of court settlement. Can 1 non-presented, Lordship, only can 2, that is, check will be issued instead of Jayanti, alias Jayanti Goran Kumari, Jayanti Lordship. Can 2 টা দেবেন তাহলে
Give me all the papers.
Can 1 টা delay আছে. Lordship, review petition along with can application 1, I am not placing, Lordship. Withdraw this.
What are you withdrawing? Review application being
Yes.
can 1.
Yes.
Can 1 review
Delay
you are
application.
withdrawing.
Delay
And can 2.
Can 2, Lordship, appropriate order are in that event, Lordship. Jayanti, alias Jayanti Goran Kumari, Lordship, Reserve Bank is obstructing. That's why, Lordship, check may be issued. Jayanti Goran Kumari, Lordship, kindly prayer person. Can 2. Register General may be issued, Lordship, in the name of
Can 2 is for the application for condonation of delay.
then can 1. Can 1. Sorry.
Is there any can?
Can, yes, Lordship.
No, there is can 1 is the review application.
No, দুটো application আছে.
No, can 1 is appropriate order.
ওই wrongly.
Can 2 is the delay application.
Lordship, that is department has done, but in this.
You check in the name of Jayanti Gorai Kumari.
Yes, Lordship. Alias part not will be entertained, Lordship, by the Reserve Bank. That's why, Lordship, it is problem. Lordship, kindly consider that point, nothing else.
Do you have any written instruction?
Lordship already sitting and my.
Settled.
Lordship-
Matter has been settled.
Lordship.
Very.
Yes, sir.
I am taking your submission.
Yes, sir.
So order was passed. Order was passed.
I'm withdrawing. Lordship.
No. That is not a withdrawal.
Nothing else.
Okay. So claimant respondent number 1.
Yes, Lordship. Lordship.
Claimant number 1.
Yes, Lordship.
Jayanti Gorai allies Gorain Kumari.
Kumari.
It has to be amended.
Yes.
Okay. So
Check
is
maybe
the-
it's in that.
I understand. There are two FMATs. One is preferred by the insurance company.
Yes, Lordship.
One is favored by the father of the region.
Claimant number 2.
Namapada Garai, Lordship.
So before the court below, before the learned tribunal, who is the claimant number 1?
One,
Jayanti Gorai Kumari
Yes.
is the claimant number 1.
Yes.
So I am mentioning only claimant number 1.
Lordship. Lordship.
Please take. Miss Siva Ghosh, learned counsel appearing on behalf of the review petitioner, submits that the matter was settled outside the court between the parties through intervention of the learned counsel for the parties.
Lordship.
Full stop. He submits that the petitioner is not intending further to proceed with this review application. Considering the submission, the review application being review 155 of 2024 is hereby dismissed as not pressed. Full stop. Connected applications are also disposed of. Full stop. The next para karun. Can 1 of 2020. This is an application for appropriate order. Ms. Seema Ghosh, learned counsel on record, appearing on behalf of the claimant number 1, submits that this court has directed to disburse the amount of compensation in favor of the claimant equally. Full stop. The claimant number 1 is facing difficulty to withdraw the amount as her name was mentioned in the passbook as Jayanti Gorai Kumari,
Lordship.
Jayanti Gorai, Garin, Kumari, Kumari. Full stop. He submits the necessary direction is required to be passed so that the check in the name of claimant number 1 be issued according to her name appearing in the bank account. Full stop. Considering the submission, also perusing the memo of appeal, it appears that the name of petitioner claimant number 1 was mentioned in the cause title of the memo of the appeal as Jayanti Gorai, alias Gorai Kumari, bracket Kumari, alias Gorai within bracket Kumari. Full stop. The name appearing in the passbook of the claimant number 1 appears to me different reasons thereby the claim and the compensation amount issued through check in favor of the claimant number 1 may be different. Under the above observation, the name of claimant number 1 stroke respondent number 1 appearing in the cause title of the memorandum of appeal is hereby corrected as Jayanti Gorai Kumari. Full stop. Jayanti Gorai Kumari. Full stop. The department is directed to make out the correction within a fortnight from date. Full stop. Next paragraph. The office of the Learned Registrar General High Court Calcutta is directed to issue the check in the name of the claimant number 1 as Jayanti Gorai Kumari. Full stop. Under the above observation, the Can 1 of 2024 is disposed of.
Grateful, Lordship. Lordship, Mr. Singh already, your Lordship.
Yes, Mr. Singh has already. Mr. Singh এর নামটাও দিয়ে দেবেন না? Mr. Singh for the insurance company. হ্যাঁ? Can 2 ওই আগেরটার সঙ্গে ডিসপ্লে করে দিয়েছি রিভিউর সঙ্গে। All applications all disposed of. FMET already disposed of. Review was pending.
I'm grateful, Lordship.
Yes.
দিয়েছে তারা দিল কাউকে দেখুন ইমাম আলী
Call the list. No one is appearing next.
Already হচ্ছে না।
Next matter. Next. Mr. Cheraji, are you appearing 28?
28, my lord.
Item number 28.
Lordship.
What is this?
My lord, for the petitioner, my lord, 28 item number. My lord, kindly short pass over. Minister Lahiri is engaged in, my lord. Short pass over, my lord, kindly.
Yes, 28.
I appear on behalf of the state, your lordship.
You are appearing on behalf of the state.
My lord, short pass over, my lord, kindly. Mr. Lahiri is on legs, my lord.
Okay, pass it over. Just wait for a while. First call. Next.
$29 for the petition.
হ্যাঁ আছে
Yes, what is the matter?
In this case, my lord, I have challenged the appointment of private respondent along with prayer, my lord, to appoint the petitioner as well as my lord, the private respondent according with law afresh.
Why?
My lord, the license initially issued in the name of the father of the, my lord, petitioner.
Yes.
My lord, the father was died in 2010.
Very well.
Before death, my lord, the license was converted into partnership firm. The private respondent was included as a partner in the firm. He was my brother. That means father and my brother was the partner in the firm. After death of my father, I approached the authority because at the time of death of my father, I was fully dependent on my father. I am a married daughter. But at the time of death, I was fully dependent and residing at the residence of my father. My representation was not considered. My approach was not considered. Interestingly, my lord, the partner of the firm, that means my brother, was appointed on compassionate ground in 2023, my lord. That is against the law. Now, my lord, on earlier occasion, your lordship directed me to read the Guru Pado's judgment, my lord. I have read
Yes.
the judgment. What judgment says, that is in my favor. No NOC was taken. No notice was served upon me. Now, my lord, kindly see page 22 of my writ petition. That is reply of RTI made by the petitioner, that without NOC, how, my lord, the license was transferred to solely in the name of the private respondent, where, my lord, the license was in the name of the firm. Kindly see the reply. Subject complaint under section 6(1). Whatever, my lord. Read with section 2J of the Right to Information Act 2005, received by this office, record number such and such. That Simoti Pratibha Roy, NOC is not required to transfer her deceased father FPS license to the unemployed brother Sri Piyush Kanti Roy on compassion on the basis of proprietorship, because during his lifetime, Rabindranath Roy and his son had a proprietorship MR business as a matter of joint venture. So it is a partnership firm. Therefore, at the time of death, how my brother became, my lord, dependent, because he has independent source of income in virtue of the joint venture. Kindly see the law. Sorry. Hmm.
Yes.
Now, my lord, kindly see the law. May I read, my lord?
Yes. What you want
Page
to read?
1.28. Clause 7, my lord. Clause 26, my lord, subclause 27.
Page 1.28.
My lord, it is my lord, the urban control order is perhaps my learned friend is. 1.28, my lord, is
This
urban.
was referred in the earlier date.
26, my lord, that regarding distributors.
Yes.
Clause 27, my lord, perhaps. 1.1.18, my lord. Clause 20, 1.18. Clause 20, clause 20, my lord, 6, 7, subclause 6, 7, my lord.
Kun page?
1.20, my lord. Engagement and compassion ground. 26.
No,
Yes, what you want to demonstrate?
no, my lord. Page 1.217, my lord. Whenever an individual licensee opt to convert its business into partnership firm for the reason of his physical incapacitation, or a licensee of a partnership firm opt to induct a new partner or substitute the name of the existing partner, the licensing authority may, on an application in form number C3 along with the annexure 1 requisite fee as prescribed in Schedule A and corroborative document as per checklist made by the licensee in this behalf, allow him to do so on examination of the inquiry report in form number L2 such and such. If and only if any of the family member of the licensee having no regular means of income is induct or
Are you a family
substituted
member at the time of death of your father?
at the time of death of my father, I am a married daughter.
Are you a family member at
I am
the time
from
in the year 2010?
I will give a judgment of the passed by this honorable division bench of this High Court, where it is stated that a married daughter can be dependent family member.
In this,
That is
because
also
my
the
lord,
separate
Lordship was earlier
I
occasion,
want
Lordship
the law, want the
Lordship
rule.
was indicated that Guru Padaja's judgment is helpful for it. My lord, that is not covered.
No, the issue is that you are the married daughter.
Yes.
And
It's
you
dependent
have
on
a brother. You have a brother. Brother was the partner of the license. Your father died. That is one of the partner died in the year 2010. Thereafter, authority has inducted your brother as a sole license. So, what is your objection? Whether you have applied for any license?
Yes, my lord, I have approached
2010, my lord, today 2024, my lord.
even that so, my lord, from 2010 to 2023.
And you have appeared
license-
before the authority
No,
concerned.
we
There
already
is no objection.
with several occasions we wrote
No
letters and
objection.
You have
sought for the
raised
instruction.
no objection and you have written there that I am living with my husband peacefully.
Yes, my lord.
This is the
And
this
his
is your
husband is a my
document.
lord bank employee. His husband also bank employee.
You have said there your private dispute cannot be appeared in this matter.
No, may I see? My lord, at the time of this.
No. You have to fair here. Otherwise, I cannot proceed.
My lord, kindly see the Guru Pada judgment, my lord.
2010 and
It is stated, but
2024.
at
No,
the
I have
time
seen
of
no.
death,
I
whether
want
he has-
your conduct to be fair.
Yes.
Why the petitioner being the married daughter had not approached the authority properly? You approached the authority that your brother may be given the license. You said that. You said before them that yes, license may be given to your brother. They acted upon your submission.
No, my lord, where my lord I have stated.
You see I have read In your writ petition, it has been stated. See the document. The right to information act document.
Three brothers and one daughter, my lord. The deceased father.
All the time you never objected, now you are objecting.
No. At the time of my lord, before issuing license, I approach the authorities. It is not, my lord, after issuing the license. I approach.
You read paragraph 20, page 22. Moreover, Pratibha Roy Sarkar fully depends on her husband monthly earning of her own subsistence. The aforesaid information gave her brother and sister.
This is the reply that I am
During
saying, my
the
lord.
sister during personal hearing in black and white in the office chamber of SCFS Basirhat.
Now I am saying that this hearing was conducted in presence of other brothers and sisters, not in my presence. My hearing was not conducted. No notice was served
Yes,
appropriately.
yes, my lord. Repeatedly notice was.
They didn't let them show the notice that he has
First of
served
all,
the notice.
2010, 2000,
That I
he
am
has
saying,
he has
no
submitted his
notice.
locus, first of all. In the meantime, 10 years he slept over his right, and when the
That's
license
why
was
my
issued,
right
my
was
lord,
curtailed.
then he come and stop
That's
the
why my
entire
right was
proceeding. my lord.
curtailed.
That is
I
not
cannot approach because 10 years.
that is not
on,
the equity, my lord.
Yes.
10 years he slept over this
My lord,
his right, and
moreover, my lord, my lord, the reply was given, my lord, on 23/9/2024. That is after the passing judgment of this group of those. In group of the judgment, it is stated specifically that in case of NOC, even if I dependent on my husband, my lord,
there is
the
no requirement
name
of
the
NOC.
name of the person against from whom the NOC is not taken, the name need to be given.
No
And the
requirement.
authority, concerned authority has to give me the notice.
According to
Nothing was done.
Gurupadas, my lord,
Rather,
if
it is
someone is
written that
dependent,
NOC is
then
not
the NOC
required.
is required. my
Very
lord.
well, it is not required. But hearing must be conducted. That reply was given by the my lord, subdivisional controller.
He must have also his application. He applied for the subdivisional controller for compensate appointment to compensate government. There is no such application is there, my lord.
So, very first is the partner who
He
is
is coming here for the stall the
already-
proceedings of the others, my lord.
already has independent source of income in virtue of the partnership power.
He has no
How can
independent
he
interest.
appoint-
He comes someone's obstructed someone's, my lord. That is main cause
That
of
is the
this.
only issue.
Yes, my lord.
Where is your application? And you have approached the authority firstly on 2021.
No. 21 not.
2021 is your first
That I
approach.
have annexed. That I have annexed.
So why you not
Before
annexed
that, before that, I have several time approached. License was issued in 2023. Even I approached for the sake of, my lord, good faith, my lord, that I have approached before issuing the license to my brother.
And it is not also proper form, my lord. 2021, not according to clause 6, my lord. Form C, my lord.
When appointing on compassionate ground, it should be, my lord, considered that at the time of date, who was dependent when who was not dependent. If the authority can say that
What is saying that পৈতৃক সূত্রে প্রাপ্ত জমিতে আমার পিটিশন পীযূষ কান্তি রায় জোরপূর্বক আমার জমিতে ব্যবসা করে যাচ্ছে 2021 till 2010, my lord, he is forcefully
that is therefore the
conducting
only
his ration
limitation
business.
ground
That can it be
is my-
possible, my lord?
No application is there for compassionate appointment. How they shall consider your approach?
It is not in
Even, my
proper
lord-
form, even, my lord.
No
Clause
application is there to give the license on compassionate ground. your only prayer is that পীযূষ কান্তি রায় যাতে আমার জমিতে পার্টিশন না হওয়া পর্যন্ত রেশন ডিলারের ব্যবসা বন্ধ রাখে।
That's
Only
the
this
main.
is the to stop.
No. I'm
This
not
is the
saying
only-
this. My prayer in the writ petition is that,
No,
my lord.
I am not.
kindly
That
see
is the
prayer.
application, my lord. That
Kindly
is the
see the
application.
prayer, my lord.
No, I shall not say the prayer.
What is the application?
How you approach before the authority, this is to be looked into first.
Because since 2000,
নিজের নাক কেটে পরে
2010,
চাপ-
Have you applied for any any submit any application for compassionate appointment?
yes. my lord.
Where is the appointment? Where is the application?
Kindly see, my lord, page 15.
Yes. What is the prayer? The ration dealership license issue
No, my lord.
cancel.
Page 16, আমি লিখিতভাবে জানিয়েছিলাম যে আমার এবং পীযূষ কান্তি রায়ের নামে, that means, my lord, I am not depriving or, my lord, obstructing my private the private respondent, that is my brother.
Where is the application?
That is the representation, my lord. I have several times approached the authority.
No,
That I am saying, my lord.
it's not the law. You have to approach the authority according to the application.
Clause
Then, my lord,
20 minus
kindly give
6.
me that liberty. Kindly give me, because appointment was done in not accordance with law. Law is saying different. Appointment was done. Right?
This is
That
the other
stands
issue
for it, my
altogether.
lord.
That
Because
is altogether a separate issue. I am not going to the issue now. I am asking you whether you have ever applied for compassionate appointment. Answer is
I
no.
representation given.
No,
my lord,
representation is separate otherwise. Why are you asking otherwise? I am asking a single question. Whether you have ever applied for compassionate
not
appointment.
in accordance with
Answer
law.
is no.
No.
Not accordance with the law. I want your specific prayer. Give me appointment on compassionate ground.
No such.
Is there
is
any
not
such representation? No. So why are you approaching this court?
But it is the duty of the, my lord, law.
That is other issue altogether.
My lord, kindly then give me the liberty.
No, I am not giving you a liberty. Okay,
My lord,
please take down.
appointment was done not in accordance with law. That will be affirmed by this court.
I am not affirming anything. I am just
that is
asking,
not-
I am hearing you. What is your authority here? You have never approached the authority. Now, this is court is not
He
the
somehow,
authority.
my lord, obstructed.
Court is not the authority. You know who is the authority.
That's why I'm saying, my lord.
No.
give me that
Court is the
liberty.
authority. Court is not the authority. You have to approach the authority.
I will approach.
That
I'm
is the
saying-
separate issue altogether. Go to the approach there. Office is open.
Yes.
Go.
He want
Yes,
to
I
beg
approach-
the backdoor entry
I
to the court,
approach
my lord.
of the-
Okay, that is the separate issue, not
That
in
is-
the.
that is
No,
not-
no,
that
my
is-
lord, that's why I say I am.
That's
give me
liberty,
that
my lord,
liberty, I will.
I am not giving you any liberty. I am not curtailing you your liberty.
Grateful, my lord.
Okay. So what is the issue here?
Very well, very well.
Writ petitioner approach this court for a necessary direction upon the concerned authority, respondent authority to cancel the license of MR dealership in favor of private respondent number 3. Full stop. It is the case of the petitioner that he is the full sister of private respondent number 3. Full stop. Erstwhile, the dealership business was run by the run through a partnership business of his deceased father and private respondent number 3. Full stop. After demise of his father, the
Private respondent of who, my lord?
private respondent 4. It is the
My lord,
next record. It
subdivision
is the
control.
case of the petitioner that after demise of our father, the authority concerned has illegally transferred the license in favor of private respondent number 4 in individual capacity without following the specific provisions of law. Full stop. Having heard the learned counsel for the petitioner, he admitted that no application was filed by the petitioner before the authority concerned for giving her appointment on compassionate ground. At this juncture, I find no justification or locus of the petitioner to approach this court by challenging the license issued in favor of the private respondent number 4. Under the above observation, the instant writ petition is disposed of. The parties are at liberty to approach this court. No, true. This court has not gone into the merit of this matter. All the points kept open. All the points kept open. Full stop. Next para, as the affidavits are not called for, not exchanged between the parties, as the affidavits are not exchanged between the parties, allegation made herein in the writ petition shall be deemed to have been not admitted. Shall be deemed to have been not admitted. Full stop. Disposed of.
Grateful one.
My lord, one thing, my lord. If your lordship kindly
Kept open, everything kept open. I am not debarring you to do it.
understand, my lord. For my satisfaction, if your lordship kindly take page 1.21, may I read?
What?
My lord, it is stated that provided that in case of death of one partner of partnership firm,
I know that provision.
only
I know that provision. I know that provision.
partner
What has to be do, what has not to do. I know that provision.
the partner have not interrupted me. I was eligible partner. I remember.
Very well. You come with the proper application. Okay, I know that provision.
Grateful, my lord.
Next. Yes.
Just giving you lordship small facts, my lord. The petitioner was appointed my lord, after a proper selection process. My lord. The vacancy was declared in 2019. My lord, license was given on 9th of January 2023.
Yes.
Now his appointment was challenged by another candidate. My lord, that petition was dismissed with cost. My lord, paragraph 7, I have narrated that fact of dismissal. So the same candidate made a complaint against him. But he complained that I did not maintain the 5 lakhs bank balance for the preceding 1 year. So that is why his license to be cancelled. Now this complaint was never given. Now straight away, my lord, at the directions of the higher authority, my lord, the subdivisional controller issued a hearing notice, no show cause, nothing, my lord, and terminated my license. My lord, I preferred the first appeal, my lord, before the district controller. He affirmed, then the second appeal before the my lord, director DDPS, my lord. This was it. Now I'll take simply, my lord, 2-3 issues. First, kindly take the notice itself, my lord, the hearing notice, page 30. As you can see. Page 30, the subject. Personal hearing regarding a complaint against a Khurshid Alam Khan who obtained a new license against a fresh FPS vacancy lost by Rakesh Sheikh, another applicant, but he was the other petitioner who replaced. In respect of not maintaining bank balance as rupees as working capital on the date of application of 1 year preceding the date of and other matter on the part of new license. Then reference, my lord, kindly mark it. Instructions of the higher authority, Food and Supplies, Government of West Bengal, sent via file number such and such. Now, what is the instructions, my lord? You also will get it from the next page, page 31. So fifth paragraph, kindly take my lord, whereas the SCFS has the losses got it. Whereas the SCFS Berampur Sador put up an e-file by Satansa to the higher authorities for answer so proper channel recommending termination of the provisional FPS license and seeking necessary instructions regarding the matter. This was done Malad prior to even hearing. Then kindly take next page 32, first paragraph. Whereas the instructions of the higher authority food and supply given received by to such and such to take necessary actions towards passing necessary speaking order for terminations of the license. There is a clear case of predetermined approach, closed mind, starting from Oryx fisheries. I will cite this judgment, my lord. This is the one illegality committed. The another illegality, there is only provisions for terminations of a license, and dealer. This is clause 24. Kindly take clause 24. Kindly just keep it in mind, this is a post grant of license. The license was granted in sometime in January 2023, and this has been this hearing notice was post grant. Kindly take 24. May I read? Page 1.24. Has the losses got?
Yes.
Page 1.24, clause 24. If a licensee or his or her agent or any other persons acting on his behalf contravenes any of the provisions of this order, first, then, or any of the regulations made thereunder, or any of the conditions of his license, or any discrepancy of stocks or in the weighing devices is detected, the sub-division of food and supply shall issue a notice to the concerned dealer asking for explanation in writing for such contravention or discrepancy. Causing here, this postulate a show cause proceedings. It's a show cause to be given. And may also place the dealership under suspension till the disposal of the proceedings by the subdivision account of food and supply. In case of suspension, the concerned ration card holder shall be tagged temporarily with the neighboring dealer uninterrupted supply of for uninterrupted supply. The licensing authority, after giving the licensee an opportunity of being heard and after recording the license thereof, may terminate the license or may reduce the volume of the business through reductions of the tag ration card imposed according to the gravity of the annex. But the question is passed, there should be violations of this control order, the conditions of license, or there may be stock discrepancy. In any event, a show cause to be issued first. That is the mandate of the provisions. That show cause alleging these violations. Then an opportunity to be given to file explanations, to submit explanation or reply to the show cause notice. Then hearing, then order of termination. And these whole actions, this is only given the power to the subdivisional controller, he cannot ask for instruction from the higher authorities. Because this should be done independently by the SCFS. Now kindly take the clause 25, this is the virtually he had taken instruction from the appellate authority. Kindly again come back to clause 25. I'll show what defect was there and what was not there.
Yes.
A dealer of APS license agreed by an order of the subdivision or controller of food and supply denies the issue of renewal of the license or cancellation of the license may prefer an appeal to the first is district controller. Then after the district controller, the petitioner is aggrieved and dissatisfied with the order of the district concerned, he may appeal against the order of the district controller food and supply to constant director DDPS. So, this is probably the higher instructions came from the deputy director or director DDPS. If the appellate authority itself gives issue instructions to the SCFS who was to act independently to terminate, then there cannot be any contrary direction, contrary reason, contrary order. Cannot be any contrary order. My lord, they allege that I had virtually the fact was that I deposited 5 lakhs and had withdrawn in the next day. But I had a fixed deposit of 6,50,000. This is still maintained from 2017 to 2027. Well, kindly come to page 28 once. Page, my lord. Sorry, my lord, page 28. This aptly satisfied the conditions of having financial, but I couldn't get an opportunity. They said the bank account which you showed that says that you had deposited and then withdrawn. So you didn't maintain 5 lakhs. But it is there, my lord. If you let them inquire, it is still there. Because it is for 10 years from 12 September 2017 to 11 September 2027 for 6 lakhs rupees. FD amount. The conditions was financial solvency. My lord, I had a financial solvency. I was given the appointment after proper inquiry. All inquiries have been made. Now, somebody challenged and his writ petition is dismissed with cost. He made a complaint. That complaint needs to be supplied to me first. A show cause to be issued. Then I shall reply and it will be independently considered by the SCFS. My lord, nothing has been done. First, the order was passed with closed mind. Before any proceeding or hearing is taken, the decision had already been taken to terminate. The second is, the procedural formalities which are mandated by the provisions have not been followed. I'll cite, these are the facts, I'll cite 2-3 judgments on that issue.
So nowadays, whether the show cause notice is required?
Yes, always.
State provision is
Always. Without show cause notice, it will be violative of the provision itself. 24, your losses, kindly see again, 24(1). It's postulated issuance of show cause notice. Without show cause notice, no penal actions can be taken. What is that? In event, your lordships know that if it is a civil consequence, show cause and hearing is mandated. The provision says show cause to be given. Kindly take another again, 24(1). The provision says show cause to be given. And if the provision, what the provisions have said, that is to be.
So what is your prayer now?
Prayer, my lord, stay, because my dealership has been terminated. And at least not to declare fresh vacancy. Otherwise, the writ petition will be infracted.
No, whether they have declared a fresh vacancy? No.
Not yet. That is why I want an injunction. In fact, my lord, the order should be stayed. Because termination order is in violation of principle of natural justice. And in violations of the provisions of the statute. I'll cite, my lord, if it's, my lord, first I will be citing, my lord, 1974 2 SCC 121. Sorry, my lord, it is 1974 2 SCC 121. My lord, equivalent citation is AIR 1974 SC 1471. Yeah. Paragraph 6 and 7. If the statutory authority bound to follow the procedure laid down. Paragraph 6 and 7. May I read? In fact, when the statutory provisions has not been followed, it has to be declared as void. May I read? The constitutional perspective must be clear in unlocking the mystique of void and voidable vis-a-vis the orders under the Act. The Act is constrained on a fundamental right, and so the scheme of Article 19 must be vividly brought before our minds. If extraordinary controls over human rights statutorily vested in administrative tribunals are to be held in constitutional lease, freedom of movement of association, profession and property are founding commitments, and several restraint thereof must be strictly construed not in the name of natural justice, an elusive phrase, nor in literal loyalty to section 59, but in plenary allegiance to the paramount law. The restrictions on the fundamental right must be reasonable, and harsher restriction, the heavier the onus to prove reasonable. The High Court, in special criminal application, held that the basic conditions clamped on the authority to hear and be satisfied according to the due process prescription of section 59 had been violated, and the order was liable to be quashed. In short, the finding was that the deprivation of the petitioner's fundamental right having been effected in a mode which is not reasonable as statutorily expressed in section 59 of the Act is illegal and unconstitutional. Once the jurisprudence of underpinnings of the section 56 and 59 of the Act are seen, the invalidatory effect is plain and unconstitutional order is void. Consequential administrative inconvenience being out of place, where an administrator abandons constitutional discipline and limits of power. What about the peril of the citizens if an official in an administrative absolutism ignores the constitutional restrictions on his authority and condemns a person to flee his home? A determination is no determination if it is contrary to the constitutional mandate of Article 19. On this footing, the externment of order is of no effect and its violation is no offense. Malad, may I just pause you one more? Here also, Malad, to carry on business, Malad, in fair price, in the essential commodities, Malad, for this is the fundamental right. Now, what are the restrictions? Restriction is these are the control orders, because under the Essential Commodities Act, Malad, the control orders are issued to impose restrictions that one should have license to carry on business. Now, this comes within the purview of 19. Now, these control order restrictions of clause 24 also comes within the purview of the restrictions, smaller reasonable restrictions imposed on the functioning of the dealer. 7. Unfortunately, Council overlooked the basic link up between constitutionality and deviations from the audio alternative patem rule in this jurisdiction and chose to focus on the familiar subject of natural justice as an independent requirement and the illegality following upon its non-compliance. In Indian constitutional law, natural justice doesn't exist as an absolute jural value, but is humanistically read by the courts into those great rights enshrined in Part 3 as the quintessence of reasonableness. We are not unmindful that from Seneca's Medica, the Magna Carta and Lord Coke to the constitutional norms of the modern nations and universal declarations of human rights, it is deeply rooted principle that the body of no free man shall be taken on no imprisonment, nor disguised, nor outlawed, nor banished, nor destroyed in any way, without opportunity for defense. And one of the first principles of this sense of justice is that you must not permit one-sided to use means of influencing a decision which means are not known to the other side. Well, here the complaint was taken, no show cause, hearing straightaway conducted, giving only 1 day time, and the order was passed on the instructions of the higher authority.
Yes.
This is the first judgment I am relying on. The second judgment I would be grateful to my junior friend. Malad, what is, Malad, when the directions of the higher authority is not permissible? Malad, that is 2011 5 SCC 435. Malad, paragraph 26 and 27. Most probably my opposite part, my learned friends in the said that, yeah, I have admitted. What admitted? The bank account was produced, it showed that the 5 lakh deposited and withdrawn. I only admitted to that extent. That yes, that is. But if it was to be asked that where was your financial solvency, I could have produced. In fact, I produced before the appellate authority. I'll come to that also. Well, 2011 5 SCC, kindly take paragraphs 26 and 27
Yes.
at 447.
Yes.
The contention was raised before the High Court that circular dated such and such has been issued by the authority having no competence, thus cannot be enforced. It is settled legal position that the authority which has been conferred with the competence under the statute alone can pass order. No other persons, even a superior authority, can interfere with the functioning of the statutory authority. In a democratic setup like ours, persons occupying key positions are not supposed to mortgage their discretion, volition, and decision-making authority and be prepared to give way to carry out commands having no sanctity of law. Mala, there is no command, Mala, under the control order, Mala, giving authority to the higher authorities like deputy director, Mala, to issue command. Thus, if a decision is taken by statutory authority at the behest or on suggestions of a person who has no statutory role to play, same would be patently illegal. Similar view has been reiterated by this court in Commissioner of Police such and such, observing that an authority vested with the power to act under a statute alone should exercise its discretion following the procedure prescribed therein. An interference on the part of any authority upon whom the statute does not confer any jurisdiction is wholly unwarranted in law. It violates the constitutional scheme. I am a thief. I have committed certain violations. But is there principles that I should be heard and I should be given a proper opportunity as per the procedure prescribed under law, and the decision making authority cannot be influenced by the higher authority. That will vitiate the order itself on the very first instance. No question of subsequent. Even the petition should have come before this court the first instance without preferring appeal. Because it's a grossly unjust, without jurisdiction, violation of principle of natural justice. Then, I will be relying on Oryx Fisheries Judgment, 2010-13 SCC 427. The paragraphs would be 29, 30, 31, and 32. Now, this relates, this is, I still realize this judgment, how this natural justice to be complied with, and what is these principles. Now, kindly straight away come to paragraph 29. This is predominantly in respect of closed mind. Closed mind, before even hearing, before even at the stage of issuing the show cause notice, and an opinion has been formed to terminate. This opinion was there. That is why I am relying on. In the instant case, from the underlined portion of the show cause notice, it is clear that the third respondent has demonstrated a totally closed mind at the stage of show cause notice itself. Such a closed mind is inconsistent with the scheme of Rule 43, which is set out below. The aforesaid rule has been framed in exercise of the powers conferred under Section 13 of the Marine Products Export Development Authority Act 1972. And as such, the rule is statutorily in nature. Here also, this control order is statutory in nature. It was issued in under Section 3 of the Essential Commodities Act, read with Section 5 of the Act. Rule 43, cancellation of registration. Kindly, I am reading it for where the secretary or other office is satisfied that any person has obtained a certificate of registration by furnishing incorrect information, or that he has contravened any of the provisions of this rule or of the conditions mentioned in the certificate of registration, or any person who has been registered as an exporter fails during the period of 12 consecutive months to export any of the marine products in respect of which he has registered, or if the secretary or satisfied that such person has become disqualified to continue as an exporter, the secretary or such officer may, after giving the person who holds the certificate reasonable opportunity of making his objections, by order, cancel the registration and communicate to him a copy of such order. Then kindly take note 31. It is of course true that show cause notice cannot be read hyper-technically. Here there is no show cause notice. And it is well settled that it is to be read reasonably. But one thing is clear, that while reading a show cause notice, the person who is subject to it must get an impression that he will get an effective opportunity to rebut the allegations contained in the show cause notice and prove his innocence. If on a reasonable reading of the show cause notice, a person of ordinary prudence gets the feeling that his reply to the show cause notice will be an empty ceremony, and he will merely knock his head against the impenetrable wall of prejudiced opinion, such a show cause notice does not commence a fair procedure, especially when it is issued in a quasi-judicial proceedings under a statutory regulations, which promises to give the person proceeded against a reasonable opportunity of defense. Then Mala 32. Therefore, while issuing a show cause notice, the authority must take care to manifestly keep an open mind, as they are to act fairly in adjudging the guilt or otherwise of the persons proceeded against, especially when he has no power to take punitive steps against the persons after giving. He has the power to take punitive steps against the person after giving the show cause notice. But here we proceed for the timing that there was a fault committed by the petitioner, but he had other things to show. In fact, kindly take page 38, once of the writ petition. This was completely ignored by the second appellate authority, because it is at his instruction this termination was issued.
Page
38. This is the second appeal. Kindly take paragraph 2 on the same page. Having all eligibility criteria, including financial solvency, in the bank on the date of application 1 year present, I have applied against the said vacancy. Photocopy of the fixed deposit document of rupees 6,50,000 for the period of 12 September 2017 to 11 is enclosed here. But this document was enclosed. Now, what the second appellate authority, well, kindly take next page, 39.
Yes.
Paragraph 5, there is first the hearing notice, then what paragraph 6, what the petitioner said. Pursuant to such hearing notice, I attended the hearing and produced all relevant documents, including the copy of the fixed deposit of 6,05,000. Now, what was the requirement, my lord? Kindly take, my lord, the notice, vacancy notice, page 25. Page 25. What was the requirement? And that was at the stage of the giving license, not after that, my lord. My lord, point number 6, fairly at the bottom, my lord. Has the lawsuit got it?
Yes.
The applicant for dealership must have bank balance of at least rupees such and such as working capital reflecting on that. But I had this capacity. If I was given the proper show cause notice, I would have defended my case. Because this vacancy notice is dated, kindly, it is dated 26th of February 2019, page 27, you will get the date.
Yes.
And my fixed deposit shows that it was maintained from 12th September 2017. Much long, much more than 1 year preceding. And none of this was considered. If you sees any of the order, none of this considered. They simply says that I had withdrawn. None of the order considered it. Even the second appellate authority, it's surprising that when this was produced before him also, he didn't consider it. Not a reference in his order. Our order you will also find from page, yes, page 44. He only went by that 5 lakhs. Middle portion, the ordering portion is page 45. He didn't consider it, it was there with him. He didn't consider that point that the order issued at the instruction of the higher authority is not permissible. He didn't consider it, decisions with reason. You also will not find any reference when it was there before him. At least he should have considered.
Yes.
In such a, let them file affidavit. I'll reply. But I want an interim order because I was running the dealership, my lord. It was terminated in March, although, but I came through these 2 appellate forums. And that they should not declare any fresh vacancy. That for the time being, I am playing. This is absolutely illegal, unsustainable order on the face of it.
Yes.
Kindly see page number 26. 25. Lordship has.
Working capital.
Yes. 6. The application for
Dealership.
must have bank balance of at least 5 lakh, brackets 5 lakh, as working capital reflected on the day of application and 1 year preceding the date of application. Now kindly turns around the page number 26. Conditions. Any suppression of fact or incorporation of wrong information in the application form will be considered as a gross disqualification for a candidate. The government in Food and Supplies Department reserve the right to reject any application without assigning any reason thereof and will not entertain any correspondence on this score. This is the very basis on which this notification has been framed, and anybody who is applying is well aware on my respectful submissions. Kindly consider the situation, Your Lordship. If I am applying for a course, the requisite criteria which are mentioned that I am supposed to have this degree, this qualification, or this and that, at the first instance, I will be eligible if I am possessing those qualifications. Then only I will make an application. Now I will move over to the orders that have been passed by the appropriate authorities. Page 36.
Yes.
Khurshid Alam, the relevant part, Lordship has heard. I have also heard my learned senior friend for quite some time, but still. Khurshid Alam Khan, FPS code number this and this, an ex-FPS dealer, village Mondal Pada, PO plus PS block, Harihar Pada, under Berhampur subdivision, has submitted an appeal petition before the undersigned on dated nil, received in this office on 27/3/2024, challenging the order passed by the SCF&S Berhampur, Vide number this and this, dated 7/3/2023. The instant appeal was taken up for hearing on 18/4/2024 in presence of the concerned applicant, SCFNS Berhampur and CIFNS at the chamber of the undersigned. On perusal of relevant case records, it has been revealed that SCFNS Berhampur has issued a termination order, Vide number, dated 7/3/2023 as per instruction of the higher authority, as Khurshid Alam Khan has submitted false bank statement in order to obtain FPS dealership at Mandal Pada, Har Pada Bazar, Daltonpur village, Mauza Harihar Pada, PS Harihar Pada in Murshidabad district. On the basis of personal hearing on 26/12/2023, Vide memo dated 22/12/2023 and on 6/3/24. Vide memo number this dated 4/3/24 in the chamber of the SCFNS Behrampur. Khurshid Alam has confessed that he did not produce bank passbook from 5/3/2018 to 15/3/2019 as he had lost bank passbook and not made any missing diary in police station. Not produced original bank passbook at the time of inquiry of his vacancy application to the inquiring officials. He admitted that the information as received from SBI Dalton branch is true. He could not deposit 5 lakhs from 5/3/2018 to 15/3/2019 in his bank account. Only deposited 5 lakh on 7/3/19 and withdrawn on 8/3/2019 the next day. Most important. He confessed his guilt for submission of false documents regarding financial solvency. Later on, after maintaining due procedure in exercise the power conferred upon the SCFNS Behrampur in para 24 of WPDS MNC Order 2013, the SCFNS Behrampur passed and termination order against the FPS dealership of Khurshid Alam Khan, FPS code number this and this, video memo this as this, dated 7/3/2023 for violation of conditions of the vacancy notification dated 12/2/2019 by submitting false documents regarding financial solvency as per WPDS MNC Order 2013 as mentioned herein. During hearing at the chamber of the undersigned, the applicant admitted that he has submitted false bank statement as a document regarding financial solvency. I have gone through the appeal petition and grounds of appeal, and as per records provided by the SCFNS Behrampur, seems to have no merit in his appeal. Considering the documents, facts, and hearing submission, and as per GO, video number 2458 FS dated 9/6/2022, the undersigned is an opinion being the appellate authority as per clause number 25 of WPDS MNC Order 2013 herein case. I find that it will be inappropriate to take a considerate view on the termination as imposed by the SCFNS Behrampur video order number this and this dated 7/3/2023. I, the appellate authority, decided that the previous termination order decided by the SCFNS Behrampur stands upheld. Now kindly turn to the last few pages, which starts from paragraph 44, page number 44. From the Joint Director, License, Khurshid Alam, Present Order. Brief case history. Case records reveal that the appellant Khurshid Alam Khan was primarily selected for filling up the fresh vacancy of FPS dealership at Harihar Para Mauza under Harihar Para block in the district of Murshidabad, which was declared BDM notification dated 12/2/2019. The SCFNS Behrampur issued provisional license to him BDA 23 on 19/1/2023. Another applicant, Rakesh Sheikh, lodged a complaint regarding non-maintenance of required bank balance as working capital by Khurshid Alam Khan on the date of application and 1 year preceding the date of application as per criteria of the vacancy notice. The SCFNS Behrampur inquired into the matter. It was confirmed by the branch manager, State Bank of India, Daltonpur branch, that the appellant had not maintained rupees 5 lakh during the period from 5/3/2018 to 15/3/2019, except the fact that he deposited rupees 5 lakh in his savings bank account and withdrew the same on the next day, that is 8/3/2019. Thus, he failed to comply financial criteria of having minimum bank balance of rupees 5 lakh on the date of application and 1 year preceding the date of application. As a result, the provisional license of the appellant was terminated by the SCFNS Behrampur video order number this dated 7/3/2024 after giving an opportunity of hearing to the appellant. Being aggrieved, the appellant filed an appeal, which I have just demonstrated, just shown before your lordship. It is a very open and shut case, lordship. There is nothing much to argue on behalf of the respondents. Certain criteria need to be fulfilled. Certain criteria are binding. You have to follow that. You have to follow the rules. Otherwise, what are rules for? If there is, if the petitioners go on to flout and we just keep sitting tight over the matters, not doing anything and giving them just sufficient ample opportunities of hearing, and they just keep moving writ courts, then what is the use of formulating these rules if they are going to be flouted like this? So on the basis of what have been the criteria, we have taken into account whatever was available He was given due opportunity of hearing. Everything has been submitted by him. Now he cannot deny that he was not present and these submissions have been recorded erroneously by us, and he is before your writ court. And with respect to the judgments which my learned friend has produced, I will have to have a look at them, and if Lordship will desire, I will again come back with the judgments, and I will try to controvert certain judgments which I will produce before your Lordship. At this point of time, I am submitting this, and I'm strongly objecting to his submission that there should be a stay of the order. These are my humble and respectful submissions, Mr. Lordship. All the documents I have very briefly, I have shown your Lordship that this was the criteria, this has been done. This is what he has submitted. And with respect to judgments, if Lordship will allow, I will come back again.
I give a short reply.
Yes.
But kindly first take page 25, the vacancy notice and the conditions at page 26.
Yes.
Now, conditions next page 26, which learned friend has relied. Any suppression of fact or incorporation of wrong information in the application form will be considered as a gross disqualifications of a candidate. This is at the stage of pre-selection. Then kindly, this is one reply, this cannot be invoked after dealership has been granted. These conditions cannot now be invoked. It was their duty to inquire. In fact, they inquired. Now they are topsy-turvy because of the complaint and probably some political interventions. Now kindly take page 36 once. Kindly first take the order of the subdivisional controller, page 31.
Yes.
Simpliciter fourth paragraph. First, I'll take third paragraph. Who was the complainant? Rakesh Sheikh. I'll cite his judgment also. His application was rejected at the stage of inquiry. Now, his complaint. Now, whereas the verification report of the bank statement of Course submitted by the branch manager statement was received at the office of such and such, it transferred from the verification that the Course had not maintained 5 lakhs for the period of 5th March 2018 to 5th, except the fact he deposited 5 lakhs on 7th March 2019 and had withdrawn on 8th March 2019. That is his SBI account. Now, there was no productions of any false bank statement. This page was annexed. Let them produce the applications. This will be evident. There was no false bank statements were produced. Because the application, most probably on 6th March, the application was filed. Then, despite this fact, kindly see the page 36. So enthusiastic district controller, because he was a page 36. During the applicant admitted he has submitted false bank statements. Where is this false bank statement? There was no false bank statement was produced. Entire passbook was not there. But that is the case, consistent case that it was lost. But there was no false bank statement produced. It runs contrary to the observation of the subdivisional controller. Again, kindly take another paragraph of my appeal. One paragraph. No. Kindly take one pleading, paragraph 11, page 7 of the writ petition. Last portion. Paragraph 11, it starts page 6. Your petitioner states that at the time of hearing, your petitioner categorically produced all the relevant documents, including the copy of the fixed deposit certificate of such and such for the period of such and such. Your petitioner further said during course of hearing, no such complaint had been handed over and supplied to your petitioner for the. After completion of the hearing, your petitioner has been forced to sign some papers. Initially, although your petitioner refused to sign those papers, however, under pressure of number of officials who were also present during the course such hearing, your petitioner has been forced to sign those documents as per instruction of the subpetitioner. Now, if your lordship goes back to page 25 and the provisions of controller, it is required financial solvency because one should be financial solvent to run the FPS shop. Well, I was granted license in January 2023. For more than 1 year, my lord, I was successfully running the FPS shop. And my applications was not cancelled at the stage of selection. And after that, in fact, district controller refers to clause 25. Now, kindly take the appeal provisions of clause 25 of the control order. My learned friend had shown that portion, my lord. Kindly take clause 25. This is an appeal.
Yes.
Any dealer of FPS license aggrieved by an order of the subdivisional and provincial denying the issue or denial of the license to the fair price cancellation of the license may prefer an appeal district controller. What is this? Well, this is after a proceedings under 24. Now, he was purportedly considering an appeal under 25. What is the order under 24? If they say that this was as per the conditions, well, it goes at the threshold. Because the conditions state was over. The district controller purportedly considering an appeal under clause 25, then it must be a clause 24 order must be there. And if there is a clause 24 order, it must precede a show cause notice. Show cause, Malad, kindly again read. Shall issue a notice to the concerned dealer asking for explanation in writing. So this cannot be sustained, my lord. Even if, my lord, they said that I had shown a bank statement, I deposited 5 lakh, withdrawn 5 lakhs, my lord, that will not suffice. My lord, their obligations under the statute. They must fulfill their obligations. My lord, even a murderer cannot be convicted since he has admitted his guilt before the police officer. There should be a trial. He should be given opportunity to defend himself.
Yes.
That's
all.
That's all. Your lordship takes your lordship's leave, my lord.
Yes. Yes.
Sorry, man.
Affidavit of service filed on behalf of the petition is taken under. Petitioner was appointed as a dealer of FPS shop by issuance of license of the concerned government authority of the respondent authority. During the subsistence of such license, of such business, petitioner was served with a notice of personal hearing by the SCFS concerned on 4th of March 2024, containing inter alia some instruction of the higher authority of food and supplies, Government of West Bengal, The petitioner appear before the authority on hearing, and after the hearing, the concerned SCFS has terminated his license. On the ground that the petitioner don't having the requisite bank balance in his account to continue the business. Against such order, he approached before the first appellate authority, who turned down the appeal. Again, he approached before the second appellate authority, wherein both the order of the first appellate authority as well as the SCFS concern has been upheld. What's upheld? As well as the SCFS concern, what's upheld? Being agreed by and dissatisfied with the said order of second appellate authority, the instant read petition has been preferred. Full stop. Mr. Sagar Bandyopadhyay, learned counsel, learned senior counsel appearing on behalf of the petitioner submits that issuance of notice for personal hearing by the concerned SCFS is itself bad in law in violation of provisions of section 24, clause 24 of WBPDS within bracket M and C order 2013. He submits that before initiation of any proceeding, notice to show cause has to be served as per provision of clause 24 of the said control order. In this case, no such proceeding, no such notice of show cause was issued. Only a notice of personal hearing was served. He further argued that the SCFS concern was acted upon the instruction of the higher authority, predetermining the fact that he had to terminate the license of the petitioner. The SCFS concern had not acted independently. Thus, the order of termination issued by the SCFS concern is bad in law. In support of his contention, he cited decisions of Honorable Supreme Court এটা লিখে নেবেন, হ্যাঁ, নোয়াবা খান, NAWABAN, Abbas Khan, ABBASKHAN versus State of Gujarat within bracket 1974 2 SCC 121. Second, or Act 3 judgment. Second name, Joint Action Committee of Airline Pilots Association versus Director General of Civil Aviation within bracket 2011 5 SCC 435. Third, Oryx Fisheries Private Limited, ORYX. Oryx Fisheries Private Limited versus Union of India. Within bracket 2010, 13 SCC, 427. By citing the relevant provisions, relevant findings of the Honorable Apex Court, relevant observations, observations of Honorable Apex Court, Mr. Bandyopadhyay argued that the proceeding adopted by the concerned SCFS in violating the concerned act is void. Mr. Bandyopadhyay also submits that the no so cause notice was issued. Thus, the entire proceeding is liable to be closed. However, at this juncture, he prayed for the stay of the impugned order passed by the SCFS concern regarding the termination of license of the present petition. Next paragraph, Ms. Sonal Singh, learned counsel, appearing on behalf of the state authority, raised strong objection. Strong objection. He submits that the vacancy notification has been specifically mentioned about the maintenance of working capital of rupees 5 lakh. It has been proved in this case that petitioner has never maintained the working capital. He further pointed out the observation of the authority and the hearing conducted, personal hearing conducted in presence of the petitioner. Ms. Singh also argued that the petitioner has confessed before the authority that he has submitted false bank statement to show his financial solvency. It is the contention of the state respondent that the order of termination is not illegal. It is on the but it is on the basis of the confession on behalf of the petition. So the order of termination of license cannot be set aside. Termination of license cannot be set aside or quashed. Having heard the submissions of the parties, also considering the materials, it appears to me that the order of termination issued against the present petitioner on 7th of March 2024 is on the basis of a personal hearing followed by an notice of personal hearing. Full stop. According to the provisions of chapter 24 of WBPDS within PDS, West Bengal Public Distribution System, PDS within bracket M and C, bracket close order 2013, the authority concerned if it appears that any dealer has violated any terms of the control order, has to issue a show cause notice. In this case, no show cause notice was issued, but only a notice of personal hearing was served. Furthermore, the notice itself mention about the instruction of higher authority of food and supply, which prompted the concerned SCFS to initiate the proceeding. Full stop. The proceeding in its threshold has to be conducted by the concerned SCFS, but in this case, it appears that the concerned SCFS has initiated the proceeding under influence of the higher authority. Full stop. It appears to me that the purported action of the state authority is dehorsed to the provisions of law. Dehorsed to the provisions of law. It has been specifically demonstrated in the impugned orders that the petitioner has admitted before the concerned authority that he submitted false bank statements. Full stop. The matter has to be considered in detail. At this juncture, I think it necessary to ask for the authority to ask the authority concerned, ask the respondent concerned to submit a detailed submit a affidavit in opposition against the writ petition within 2 weeks after vacation. Reply, if any, by the petitioner within 2 weeks thereafter. Full stop. Next one. Considering the entire facts and circumstances of this case and considering the merits of this matter, it appears to me that prima facie the present petitioner has demonstrated his right to have an order of stay in respect of the impugned orders passed by the concerned passed by the respondent authority, concerned respondent authority. But it appears to me that the order of termination was passed in March of 2024. Now we are completing the year. Now we are completing the year. So at this juncture, I find no urgency at this stage to issue an order of stay. An order of stay in respect of the impugned order at this juncture. Full stop. Accordingly, the prayer for stay of the impugned order is hereby refused at this time. Full stop. Let the matter appear in the list on 27th of January 2025 under the same heading.
No vacancy in the meantime at least.
Okay. তাহলে ওইটা করুন তাহলে the authority concerned ওইটা করার ওইটা করুন I find no কি বলুন লাস্ট একটা বলুন তার আগে বলুন তার আগে সেন্টেন্সটা
In terms of prayer J, man.
To pass an order to issue an at this stage. তারপর করুন however এখানটা অ্যাড করবেন however however there shall be an order upon the respondent authority in terms of prayer J,
Prayer J.
prayer J of the writ petition till further order. Till further order.
In fact, the last appellate authority order was passed in September 2024. Immediately thereafter, we filed the writ petition.
Okay.
And nothing virtually happened, only the tagging.
Okay. Grateful, man.
Pressing for stay of the orders.
Next.
Or I'm for the petition. Straightway kindly turn to page 23 of the register. Page 23.
Yes.
This is the vacancy for February job at Morarthi Fair Junior High School, near Junior High School. At Dadpur, Rajinagar, Murshidabad. Then kindly turn to my page 26. The indicative notice has been issued in the newspaper, serial number 24, kindly see.
Serial number 24.
And the last line, it is not so legible of the page, 21 days.
Yes.
From the date of 13 January 2016. I submitted my application on 26th of January. It will appear from page 27. Within time.
Yes.
Then my a notice has been issued for conducting inquiry. That will appear from page 28. Page 28. But on that day, inquiry has not been conducted. Then a next notice has been issued. Kindly turn to page 29. On 30th March 2023, inquiry has been attended. They will kindly turn to page 32. I lodged a complaint with the authority concerned saying that one of the candidates is a brother, is a dealer. So he should not be given appointment because I am the most suitable candidate. I came to learn that you are going to issue appointment letter in favor of Sheikh Asif Ahmed, which will appear from page 32 after 4-5 lines. With specific allegation that the sub-divisional controller is going to issue appointment letter in favor of that gentleman, although I am the most suitable candidate and his brother is a dealer which is barred to get any appointment. I made a detailed representation also. If you also kindly turn to page 34. I'm sorry. Specific allegation against a particular candidate.
Yes.
My page 34 is the detailed representation. Once again, I have made on 22nd of January 2024. If you also kindly turn to page 35. Again, I have written my last paragraph of page 35. The same thing. Page 38 is my further demand justice addressing to the sub-divisional controller, writing the same. No steps have been taken, and I made a RTI application. So kindly straightway come to page 42. Addressed to the SPIO ATC Additional District Controller Murshidabad. This has been submitted on 19th September 2024 under the RTI Act. Kindly come to my serial number 6. The question: the present condition of new vacancy at Moradiki near Moradiki Junior Basic High School under Beradanga block. The present condition. Have you also got my? Kindly come to the reply.
On 24th September 2024, subdivisional controller gave me a reply at serial number 6 as to query number 6. None of the 14 candidates have been recommended. The said vacancy is expected to be notified.
Re-notified.
Re-notified. Then another application I have submitted before the other authority. And what is the answer? Kindly see page 44, serial number 6, the same query. That the mentioned vacancy ID currently under process. There is the SPIO assistant director, much higher authority. Subdivisional controller is under the process, and the assistant district controller, who is the higher authority, that the current under process. Have you also got my lord? Serial number.
SCFS says it has to be re-notified.
Re-notified. So there is the process. Process has been concluded. Now kindly turn the next page. The assistant district controller, who is the higher authority, that the mentioned vacancy is currently under process. Well, I have made out a case in paragraph 20, 21, and 22. If you also kindly turn to page 10 of my repetition.
So what is your prayer now?
Now I am paying my lord not to declare any vacancy because I cannot say that grant me a license. They are going that from their document it says they are going to declare the vacancy, not to declare any vacancy. Let the matter be heard on a very.
They are saying that they will re-notify the.
Yes, but that has not yet been done.
No.
So if the notification is given and third parties are applied for, then there will be a third party interest. I have made out at least prima facie case. They are not saying that for that ground your application has been rejected.
No.
There is no disclosure.
Whether you have said that whether what is about your application.
But the RTI will kindly see.
If you have said that what is my status regarding
how many applicants are applied for page 42, whether inquiry on all proposals from go down site have been completed, the inquiry report of all the applicants against the said vacancy are completely true. Please provide the extra copy of medical certificate so and so, whether any of the applicants is finally recommended. Nothing has been intimated. Serial number 3, kindly see. Report has not been handed over to me. Nothing.
No, query number 5, no, none candidates have been finally recommended for granting license.
That has not been, what is the answer? If I go through the last document, that is, the vacancy is under process. Nothing has been intimated so far this particular gentleman who against whom I specifically raised the allegation.
You are saying that you are the most suitable candidate.
Yes. Let them file the report or affidavit.
Let a report be
Fine.
Okay. You are appearing for the state respondent. You submit a prompt report. Considering the submissions of the petitioner that he being an applicant for a license of a dealer by virtue of memo number 138 1381 to the page 20 dated 27/12/2022 had applied for the license. Full stop. It is the case of the petitioner that he has complied with all the formalities. Full stop. It is the further case of the petitioner that he is the most suitable candidate for the for having the license. The case was demonstrated before this court by the petitioner that the authority concerned has illegally used to re-notify the vacancy on the ground that none of the candidates has fulfilled the criteria. At this juncture, the petitioner prayed for stay so that no new vacancy may be declared. No new vacancy may be declared in respect of the cited location. Full stop. Learned counsel, next part, learned counsel appearing on behalf of the state authority submits that he need instructions from the concerned authority. Full stop. Having heard the submissions of the parties, it appears to me that before disposal of the matter or before issuing an order of stay, it is required to peruse the report of the concerned authority. Accordingly, the authority concerned is directed to submit a report within a week. The report must coupled with an affidavit. Coupled with an affidavit. Let the matter appear in the list under the same heading. On 11. On 11.
Lordship, after 15, Lordship.
After 15.
In that case, your lordship, I am praying for an interim order.
Come on 15.
No, Lordship.
You come with a report. I did not require any affidavit. Okay, ছেড়ে দিন, ওই যে submit a report বলুন। ওই যে তারা বলেছে ওই কেটে দিন, report master affidavit কেটে দিন। You submit a report, okay?
Hello, direction may be
Yes, Lordship.
if they on the pray for adjournment, kindly record my lord, the direction is preempted.
Okay. The direction as passed above against the authority concerned is peremptory in nature.
Much of it.
Affidavit of service filed on behalf of the petitioner is taken on record.
Item number 52.
Yes, item number 52. Give me the. Give it. What is your name?
My name, Miller.
Yes.
Mahadev, sir.
Are you the advocate on record?
Yes.
Please take down. Mr. Mahadev Sarkar, learned advocate on record, appearing on behalf of the petitioner, submits that he received instruction from the petitioner that petitioner is not intending to proceed further with this matter. Mr. Sarkar has handed over a written instruction from the petitioner. Full stop. Let the written instruction be kept in the record. Full stop. Next para. Having heard the Mr. Learned counsel for the petitioner, and also after perusing the written instruction of the petitioner, comma, the instant read petition is hereby dismissed as not pressed.
I'm grateful.
Item 40 my
I'm
lord,
grateful.
service is not complete.
নাম তো আছে।
There is a private respondent, so your lordship kindly not this week. Item 40.
Item 40.
40. I am the advocate record.
Not this week.
Not this week.
Okay, I am 40. Not this week. করে দেবেন।
Only 40.
Call the list.
My lord, today the college authority is going to submit. My lord, I am led by Mr. Raghunath Chakraborty. He's engaged in courtroom number 26, but I will start with my submission.
Yes, you can
Yeah.
start it.
I am appealing for respondent number 6.
My lord, as it is known by us, there is a history of protracted litigation in this matter.
শুনতে পাচ্ছি?
Shall I start, my lord? Yes. So, my lord, there is a history of protracted litigation in this matter.
Take the mic.
My lord, there has been a history of protracted litigation in this matter. Has been a 2 round of litigation. This is the new writ which has been filed by the petitioners. So, my lord, I'll first draw your attention to the prayer of the first writ petition. That was, my lord, 10275 of 2022. That was the first writ petition filed by the petitioners. My lord, come to the prayer portion. It is in page 15.
You are appearing on behalf of Sarojini Naidu College for Women.
Yes, my lord.
Yes, you are referring page number
15, the prayer portion, my lord, of the first writ petition.
Page number 15 of the writ petition.
Of the first writ petition, my lord, that is WPA 10275 of 2022.
What is it?
My lord, they referred last occasion, they have asked for the file was here, my lord, with you.
File is here.
Yes, my
Okay, give me the files. After registration.
There is no paper book, my lord. That's a very difficulty because
Paper book in writ petition.
my lord, there are so many papers. 10275. Yes. You got it, my lord?
WPA 10275
Yes, my lord.
of 2022.
Yes. That was the first round of litigation.
Yes.
Filed by the petitioners. My lord, kindly come to page 15.
Yes.
Yes, my lord. The subject matter of the challenge was, my lord, they asked for directions to immediately set aside, cancel, withdraw, squash the letter dated 5th May 2022. My lord, though this letter dated 5th May 2022 is a wrong, wrongly written, it would have been 15th May 2022. So the letter of termination, that was the subject matter of challenge. So then they have asked for Directions to allow petitioner number 1 and 2 to continue to provide uninterruptedly service in terms with the MOU dated February 6th, 2019 to the students of the 3 years BBA course. So this was the subject matter of challenge in the
That was
first
the prayer on the earlier
Yes, ma'am.
petition.
Now I'll draw your attention to the prayer portion of the second writ petition filed by the petitioners.
This writ petition,
Yes, my lord. 27376 of 2022.
274 or 273? 273.
Yes, my lord. 76 of 2022.
This writ petition.
Yes, my lord. Present writ petition. In this writ petition, my lord, the prayer portion starts from page 50. My lord, if you come to B, the same prayer has been sought for.
In
That
the
is-
prayer A, they have challenged the regent order.
Yes, the order passed by the DPI. Then the same thing to immediately set aside, cancel, withdraw, squash the letter dated 5th May 2022, being the termination letter and annexure P4. My lord, the same. The number is the date is wrong. It's not May 25, 2022.
Copied and pasted.
Yes, my lord. Then C also the same prayer.
Allow them to
Yes,
continue
my
with the
lord.
BBA course.
Yes, my lord. So the agitation of the petitioners have been on the same subject matter. In addition to the last writ petition, there has been a challenge on the order, reasoned order passed by the DPI. Next, my lord, I will draw your attention to the order passed by Honorable Justice Kaushik Chando. That is in page number 93 of the present writ petition.
রাখুন নিচে। এখানে রাখুন, এখানে রাখুন।
17th August. My lord, the final order was being passed on 17th August 2022 by Honorable Justice Kaushik Chando. It's in page 93.
Yes.
93. May I kindly come to page 5 of the order. It's in page 97.
Near page 5.
Yes, my lord.
Yes.
The second paragraph, my lord. In the present case, having regard to the disputed question of facts involved in this case, I am inclined to give a direction upon the state to issue appropriate direction in terms of Section 18 of the West Bengal Universities and College Administration and Regulation Act 2017. In view of the matter, I dispose of the writ petition giving a direction upon the Principal Secretary, Department of Higher Education, to depute a competent officer to look into the grievance of the petitioner as made out in this writ petition. The said officer will pass the appropriate directions after hearing the college as well as the petitioners. Let such decision be taken within a period of 4 weeks from the date of communication of this order. Till such decision is taken by the said officer, the order of the termination dated 15th May 2022 shall not be given any effect to. So, my lord, a competent officer was being deputed to look into the grievance of the petitioners.
So you being the college authority allowed them to
Yes, my
continue the
lord.
BBS course? In
What,
terms
my-
of the order,
Yes, my lord.
in terms of the order, till such decision be taken, the order of termination dated 15 May 2022 shall not be given any effect to. What does it mean? Whether you are allowing them to continue the BBA course?
Till such decision is taken, my lord, by the DPI, the order of termination shall not be given effect to. So the
What does
order
it
of
mean?
the
Whether you are allowing now,
no, my lord.
you are not allowing.
No, my lord.
Okay.
The DPI has passed the reasoned order.
Now, after the such order, whether you have allowed them,
No, my lord.
you have not allowed them. Yes.
Yes, my lord. My lord, the same issue, the termination of the MOU cannot be subject matter of the multiple legal actions. My lord, I will draw your attention to page R1, R2 of the opposition filed in the first round of litigation, my lord, 10275 of 2022. My lord, did you get the opposition of the first round of litigation?
What you want to demonstrate?
My lord,
What is your ground here?
My lord, I want to show you the affiliation for the BBA-TAH course from the WBSC, BSU, which was for the year 2019-20, 2021, and 21-22. So the affiliation also got over 2021-22. That I wanted to show you, my lord, from the opposition, which is in R1, page 21 and 22.
R1 টা বের করুন।
One 10275. Now, opposition. Affidavit in opposition. Respondent number 4. Yeah.
This is R4.
Patient.
This is AO of R4. Give me R1. AO of R1.
পাইপ পাইছেন পাওয়া যাচ্ছে না এটা দিয়ে দিলে হুম 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 ফার্স্ট জুলাই বললেন যে ফার্স্ট জুলাই
কোনটাই বলছি, এইটা না কোনটা?
হ্যাঁ হ্যাঁ ফার্স্ট জুলাই
10275,
হ্যাঁ হ্যাঁ
এটা দেখো তো, R4 বলছে তো, না R1, R4 বলছে। ওকে, ইয়েস, প্রসিড।
yes my lord. My lord, kindly come to page 21.
Yes.
My lord, this reflects that the Sarojini Naidu College for Women got affiliation for the BBA honors in TAH from the West Bengal State University by letter dated WBSU IC dated so and so dated 24/5/2019 for the academic session 2019-20, 2021 and 21-22.
Yes.
It's reflected in number 1, my lord. BBA in tourism, aviation and hospitality.
Yes.
My lord, kindly come to the previous page, 20 of the opposition. My lord, there is it is a letter of the college to the director of the Avalon Shiksha Niketan in response to the West Bengal State University letter wide number so and so 24/5/2019. I would like to inform you that the affiliation of the above BBA in tourism, aviation and hospitality 3 years degree course offered by Sarojini Naidu College in collaboration of Avalon Shiksha Niketan has been granted by the Honorable Vice Chancellor of the West Bengal State University for the academic session 2019-20, 2021 and 21-22.
Yes.
I would like to draw your attention to the fact that this letter was never annexed during the first round of litigation. This letter was never annexed. So the affiliation was up till, my lord, 2021-22.
No, this is the affidavit in opposition of respondent number 4 on the earlier litigation.
Yes, my lord.
So what are you submitting?
My lord, this letter has never been disclosed by the petitioners.
Okay.
Regarding the affiliation, regarding the fact that the affiliation was for 3 years only, initially, 2019-20, 2021 and 21-22 only. That fact has not been highlighted.
So these are the 3 years course.
Yes, my lord.
So
and the affiliation was
admitted in the year 2019-20 batch,
yes,
academic session.
Yes.
They will continue till 2021-22.
22. Yes, my lord.
So whether there are any admission of 2021-22?
That was taken, admission was taken, 2021-22. But the affiliation was over on 2021-22.
Affiliation means what? They shall continue or say they shall close the all chapters?
No, my lord, that depends whether the college wants to run the course or not. That is dependent on several factors, my lord.
So what you want to submit in this matter?
I'm taking you to the facts, my lord. Thereafter, my lord,
So a student who was admitted in 2022 session, 21-22 session, he has to complete 22-23, 24-25, 25-26.
Yes, my lord.
So if there is an affiliation, the student has to conclude the course up to 2026. What is your submission now? You are saying that only up to 2022 there are affiliations?
Avalon is just a collaborating partner,
Yes.
and they cannot force the college authority to continue a partnership indefinitely. And the college has the right to make decisions in the best interest of the institution and the students.
They have challenged the order of termination as it is perverse.
Yes, my lord. There has been two rounds. This is the second round of litigation. The
No, what
DPI.
is your submission regarding their submission, Mr. Roy?
Yes, my lord.
What is your submission regarding the submission of Mr. Roy that the termination is perverse?
The termination is not perverse, my lord. It is a decision taken by the governing body of the college. And now I'm taking you to the extract of the GB, my lord. My lord, kindly give me some time because I'm confused with so many papers, my lord.
You are not ready today?
My lord, I'm partially ready. I'm being led by Mr. Chakraborty, Mr. Raghunath Chakraborty.
Then you take your time. Come on next week then. Record. Please take down.
My lord, Mr. Chakraborty has come.
The doctor is ready. Yes.
Yes, this is second round of litigation, Lordship knows, my lord. The earlier round of litigation, my lord, every question was taken into consideration. And thereafter, my lord, the court was kind enough, court was kind enough to observe that there are disputed question of fact. Lordship knows, my lord, contractual obligation. And as a result of which this, my lord, writ application, my lord, cropped up. Now, my lord, there was a direction, my lord, to the DPI to look into the issue and adjudicate the whole issue. And it was placed before the DPI authority, and DPI was kind enough to hear all the parties and come to a conclusion and directed us to pay, my lord, the admitted amount. We never deny the admitted amount. We are not in a mood to deprive them in any manner whatsoever. And that 32 lakhs we have tendered them, they have accepted it. Yes, my lord, it may be without prejudice to their rights and contention. Now, my lord, on the last occasion when I was here, my lord, to look into the, my lord, and hear the hearing of a petitioner, I have seen, my lord, innumerable papers and document of our previous, my lord, the cases where, my lord, before this honorable court. Lordship knows, my lord, previous occasion also the termination letter was challenged. And on the basis of that challenge, Justice Chandra was kind enough to pass the order. And on the basis of that order, DPI has passed this order. My lord, that order of the Justice Chandra has assumed finality. One cannot raise, my lord, repeatedly raise this question and keep on raising this question. My lord, the particular term in the civil procedure code, that is res judicata, the constructive res judicata is there. My lord, at that point of time, the question they have raised, they are not at their liberty to raise all those questions again. My lord, in the event they are aggrieved and dissatisfied with the order of Justice Chandra, they are, my lord, the appellate forum was also there. That, my lord, they did not seize that opportunity. Without seizing the opportunity, the order passed by the Justice Chandra, my lord, they appeared before the, my lord, DPI authority and placed their contention. If that be so, my lord, now today itself standing, today's, my lord, atmosphere, whether they are in a position to raise all this question in any manner whatsoever. My lord, the question they can raise only, my lord, the order in the four corner of the Director of Public Instruction. Not more, not less. But they are not confining to this, my lord, the boundary. My lord, they are crossing the Lakhon Rekha in this fashion, my lord, which is not permissible under the law. Now, innumerable judgment are there. When I have left, my lord, particular, my lord, the pleading, when I did not raise objection against that, that is abundant pleading. And, my lord, I will show, my lord, the next day number of judgment to show and substantiate they are not there at their liberty. My learned friend, my lord, already submitted that there are, my lord, certain, my lord, problem, all these things are there, including the question of security of the students are there. They are, my lord, deputed in a particular hotel, and the, my lord, the client are over friendly, requested them to be in their room. When we received this information, as being an institution, as being a head of the institution, we took initiative. My lord, they are denying it. Then, my lord, this is a disputed question of fact. For disputed question of fact, they are to adjudicate and approach the appropriate forum. They have already received their admitted amount. For remaining amount, my lord, the civil court is open, my lord. They are at their liberty to go there. My lord, this is our second fold argument. Third argument is, my lord, we are to run collectively by our, my lord, the elected committee or committee, my lord, and my lord, the Pranam Dhar's report is also there. He is, my lord, the chairperson of the Board of Studies. His report also in favor of taking action against them. And our college authority also taken action against them. And as a result of which, my lord, we have terminated their agreement. And at the same time, lordship, possibly my learned friend indicated, this was up to 21-22. Standing in the, my lord, in 24, and on the, my lord, 25 is approaching, we cannot raise any question with regard to, my lord, a fact which is infractuous nowadays, my lord. These 3-4 aspects are there, my lord. On the next day, we will submit, my lord, before this honorable court, some judgment. And, my lord, my learned friend, my lord, referring some disciplinary proceedings related judgment, my lord, before this honorable court. My lord, natural justice has been violated. No papers has been supplied to them. All these questions. My lord, they did not feel free to ask for all those documents from the appropriate authority. Maybe college authority is biased. Maybe college authority is taking some action against them. But DPI authority, my lord, court deputed DPI to look into the issue. My lord, they did not show any scrap of paper that they have applied before the DPI authority, my lord, to supply all those documents. Now they cannot take this plea unless they are in a position to show their prejudice for non-supplying all these documents. And, my lord, the document which they are asking to supply, my lord, the document also says, my lord, certain things are there, books not supplied, my lord, the internship not arranged, and, my lord, those who are, my lord, in deputation in different, my lord, the organization, the working atmosphere is bad. Lordship knows, my lord, after Bishaka judgment in workplace violation, law is also there. My lord, this little girl is not in a position to take that action in that workplace also. So we have to take action, as a result of which we have decided to say, my lord, the unavoidable circumstances are there. We are not disclosing it because as soon as disclosure is made, the name of the student will be disclosed. Sometime, my lord, this is permissible by the law, as a result of which, my lord, the arjikar, my lord, the lady student is nirvaya or abhaya, my lord. That being the situation. My lord, considering all these aspects, my lord, this is our basic frame, and they cannot do all these things at this juncture. My lord, that has assumed finality the first full litigation. Second full litigation, they should confine to the four corner of the DPI order. My lord, kindly allow us to come back on the next date. Next date we will conclude it.
No, you have concluded all the matter.
No, my lord, the judgment is required to be placed.
Okay, judgment you can place it. No.
Or at the same time, my lord, showing, my lord, to some 2-3 documents. I shall not take more than 50 minutes, my lord, on the next date. But I have collected the judgment, my lord, because of my
instruction is the main.
They are to defend their order, and we were there. They have directed us to pay them immediately 32 lakhs. It is compliant. It is compliant. So challenge is required to be made. Challenge to be made against the DPI order. And, my lord, the remaining question, we are making allegation that you are not behaving with our girl student in an appropriate manner. They are disputing it. So all these questions are required to be proved, putting someone into the dock, not in the writ court, my lord.
Yes.
Writ court cannot adjudicate the factual aspect, and all this disputed question of facts are there. Even Justice Chandra was kind enough to observe there are disputed question of fact. As a result of which conciliation, arbitration, like that, my lord, lordship knows, in civil procedure code there are provision for conciliation. Keeping in the mind, my lord, that particular provision, possibly, my lord, this was relegated before the DPI. Since DPI, my lord, my lord, the university is there, my lord. University, my lord, approved this particular scheme, my lord, and 21-22, it has been ended. Now this has become infractuous also.
Very good.
So, my lord, next Tuesday, my lord, I will come back and judgment, or any date, my lord, any date, as lordship pleases.
No. Can you today proceed to hear DPI?
Yes, my lord. Yes,
You can produce the.
allow me, my lord, 10 minutes time, judgment and submission, if any, my lord, left out, I will.
No,
my lord.
if you conclude your submission, then I can.
Then,
proceed,
my lord,
otherwise,
I may be allowed to come back, my lord.
then I cannot proceed.
I may be allowed to come back
I
because
can
of
allow
my
you to submit the
my lord,
judgment.
huge preoccupation in the court number 26, my lord, today itself, my lord. And I am to do justice so far my client is also concerned. My lord, not really applied my complete mind. Allow me, my lord, to come back for 10-15 minutes and then, my lord. Or any date, my lord. Today is
Let
Tuesday.
him conclude. Thereafter, you can start. You are the answering.
Since I am told, Sir Roy will also be there, so it can be finally.
Finally,
No
dispose of
circuit.
the matter.
No, sir.
No circuit.
No circuit. Very well. Please take down.
Ultimately, we have to go to some other points. The only point will come up whether the college authority itself can delegate a power which they themselves doesn't have.
Exactly.
That will be my moot argument that has to be the crux of this issue.
The reason order is there.
Yes, because like that of a lease, if the lessee doesn't himself have the power to sublease, he is subleasing more than the term 10-year. That will be the moot contention of the, because the PI has given them for a particular period. Otherwise, it would have been an open affiliation for n number of years, a specific number of years. What is their privity of contract doesn't bind the DPI or the state. So that will come up.
Okay. Argument on behalf of the college authority, heard in part. Let the matter appear in the list on next Tuesday. Next Tuesday, 10. 10. At 2 p.m. Deeply obliged.
Unless this letter is issued, then the thing would have been, we would have smelled something otherwise, that they have a nexus to continue by virtue of a agreement between themselves, which they cannot.
Yes.
I am for the respondent, Lordship. My learned. It is, Lordship.
No, residential.
Very interesting matter, my lord. And I'll be very brief because the facts will take, my lord, a lot of time. The second appeal, I'll indicate the points.
My lord, item number 4, my lord, this my lord 2 p.m. fixed up.
Yes.
So this matter will continue sometime, my lord. Another content matter, my lord, I'm in that. Court number 50.
Your item is?
Item number 4. 5. I'm in 4. 4, 5. 4, 5. Both are
4 and 5.
4, 5 both. They are with me, my lord.
No, this is quarter matter. I have heard this matter.
Yes, my lord. Another content matter, my lord, fixed up at.
So what you want?
Next, another date, my lord.
Another date is next Tuesday.
Next Tuesday. Now this matter will continue.
No. It will continue, no issue.
But I am coming back on next Tuesday.
Next Tuesday. Very well. I will not call them. Yes.
May I first indicate, before I request your lordship to take up and permit me to read the orders, the first judgment and the second judgment. May I first indicate broadly what is the matter? And my lord, since it's a second appeal, and there is, my lord, no impediment in my taking up the points of law which perhaps should have been taken in the previous proceedings.
Yes.
But as it appears, the matter as it appears, my lord, your lordship has the genealogical table, my lord. We had handed over a genealogical table on the last day. My lord, Kalicharan Das was the original, my lord, owner of
two properties. If your lordship kindly notes at the bottom of the genealogical table, your lordship will find the two properties. First, 4/1 Shankar Bose Road. But kindly note that that's property number 1. 4/1 Shankar Bose Road. Your lordship will note the next property, 32A Rakhal Das Oddi Road, Thika property. This is an admitted position. So the present dispute may not belong between the parties is based on these two properties. Now, who is the plaintiff and who is the defendant in the proceeding? Your lordship will find from the genealogical table, Kalichorun Das, his wife Bhutimoni Das, that's the second, the first line. They had 3 children, elder son Gopichorun Das, younger son Krishna Chorun Das, and daughter Bimola Hajra. You will kindly note Bimola Hajra, the daughter, is the plaintiff in the proceeding.
Yes.
So, my lord, it was Kalichorun Das, Bhutimoni Das, his wife, 2 sons, 1 daughter. Kalichorun Das passed away in 1935. This is before the Hindu Women's Right to Property Act of 1937. So, my lord, at that time, it was the law was not codified to protect the right of Hindu women. It was codified to such effect in 1937. Thereafter, my lord, the Succession Act comes in. Bhutimoni Das leaves for heavenly abode. The date is given, my lord, 22nd of April, 1971. Leaving behind her the elder son, Gopichorun Das. Your lordship will find Gopichorun Das, his wife was Reba Das, 2 sons and 2 daughters. They are the present appellants before your lordship.
Yes.
They were the defendants in the suit. So the suit is between Bimola Hajra and the defendants. That is Reba Das and the sons and daughters of Gopichorun Das. Gopichorun Das passed away in 1999. Your lordship has got that, my lord?
Yes.
My lord, what is the suit filed for? The suit is for partition of these 2 properties. Now comes a very interesting part. The suit is premised on the argument in law that Kalichorun Das passed away in 1935. There was a right to maintenance which subsisted with Bhutimoni Das, the widow. And this right of maintenance crystallized when the Act of 56 came in because of Section 14. So any right that she had has crystallized into, so a right of maintenance will also crystallize at Section 14. We are all aware, my lord, I will not make an argument which is absurd in law. So their argument is this is crystallized in terms of Section 14, and upon crystallization, this becomes a heritable right. So if it becomes a heritable right after 56, when she passed away in 71, the property stood 1/3 for the elder son, 1/3 for the younger son, and the daughter, the plaintiff in the proceeding, was entitled to 1/3 of the share. That is their case. Now, the daughter comes up as a plaintiff, files the suit, prays for partition. That's the case made out by the plaintiff in a nutshell. The argument, the legal argument that they are relying on is the chain of rights which flow from the 1937 Act, which has been amended thereafter repealed, with the 56 Act. That's the very basis and fulcrum of their submission, of their stand. Now here, my lord, kindly note two facts, admitted facts, and I'll show it from the first judgment. That perhaps seals the matter. It is contended by the plaintiff all throughout that there is a chain through which Bimola Hajra has got right in the property. And that chain has come in through Bhuti Monidas. It's a suit for partition of these two properties. Now let's look at these two properties separately, my lord. For once, one is a Thika tenancy property, which is admittedly a Thika tenancy property. And the second, the allegation in the plaint is very interesting. The allegation is that this property is tenanted. Since the property is tenanted, we have never received rent. We means the plaintiff. The plaintiff has never received rent. The plaintiff is entitled to rent because of the 1/3 share. Since it's a tenanted property, she's entitled to 1/3. Hence, now she wants partition because amount has never been given. In the process, what is admitted is the fact that the property was tenanted. The admission that the plaintiff was never in possession of this property is also an admission, and I'll indicate that Bhuti Muni Das was also not in possession of the property. That's the first property. That's the non-Thika tenancy property. A very recent Supreme Court decision on this point. It's not even a week back. Carrying that states it's an interpretation of the same.
Bhuti Das was not in possession of the non-Thika property.
Was never in possession of the non-Thika property because the non-Thika property was with the tenants. It was a tenanted property.
4/1 Shankar Bose.
4/1 Shankar Bose Road. And this is very important, my lord, for the entire proceeding. If it's a admission that there were tenants and we want rent, we have never got that rent. The corollary to that submission would be that it was occupied by tenants, not in your possession, not in the possession of the predecessor in interest of the plaintiff, Bhuti Muni Das. So that right to crystallize possession is the most important factor. The Honorable Supreme Court in the recent decision also elucidates the same principle, that when the law trickles down to crystallization through the route of section 14 of the Hindu Succession Act, that has always to be looked into through the prism of possession. If possession is not there, then the crystallization never happens. Mere maintenance, and whether this property was for her maintenance, it's not. Because by then, the elder and the younger son, they were minors. When Kalicharun Das passed away in 35, the elder son and the younger son were minors. They attained majority before 56 Act. Now this is very, very important. The moment they attained majority, the very reason for which Bhuti Muni Das was in charge goes. And that's a fact that's recorded in the first judgment. Now, before I move on and indicate I read out the relevant parts of the judgment, in fact, the entire judgment would be relevant. May I first lay down the contours of my submission on law. Since it's a Thika tenancy property, which is a Thika property is admitted, it's a fact which is not disputed by both the parties. 32A Rakhaldas Audi Road.
Yes.
My lord, there are some impediments in the suit being maintainable. At the very outset, this suit could not have been permitted to be carried on with for the express bar with regard to a suit property.
That is 32A Rakhaldas Addi Road.
That's 32A Rakhaldas Audi Road. Petition order. I have it. Lordship may kindly take up the issues in the second appeal while the appeal was being admitted on 5th of October 2010. And I'm indicating this so that the premise of my submission does not falter and go beyond the admitted issues. Kindly take up the order of 5th of October 2010. There are three issues on which, my lord, the second appeal has been admitted.
October 5th?
5th of October, my lord.
Yes. Substantial question of law.
Wait, see it. My lord, the first is whether the learned judge in the court below substantially erred in law in not holding that after the death of Kalicharan Das in the year 1935, the sons became the successors, and as a result of which the plaintiffs have no vestige of right in the property in suit. So that's on the right. Second, whether the learned judge in the courts below substantially erred in law in not considering that the property vested to the sons after the death of Kalicharan, the plaintiff is not entitled to any share in respect of the property in suit. And the third, whether the learned judges in the courts below substantially erred in law in not holding that the suit filed by the plaintiff is not maintainable. I'm on issue number 3. So it's kept open in the second appeal as to whether the suit at all was maintainable. And I'll indicate why this point was kept open. My lord, admitted position of fact is that 32A Rakhaldas Audi Road is a Thika property. That's an admitted position.
Yes.
There are three difficulties that the suit faces when the admitted position is that one of the properties of the suit is a Thika property. The first difficulty which they have to overcome is, my lord, the bar under section 21 of the Act, the Thika Tenancy Act of 2001. I'll indicate that, my lord. I'll come to that point. I'm only giving a broad overview of the submissions. Bar to jurisdiction read with section 5 of the Thika Tenancy Act, because the bar reads, may I hand over a copy, my lord?
Yes.
Take to Judge quickly. Section 21, bar to jurisdiction.
Yes.
No civil court shall have jurisdiction to decide or to deal with any question or to determine any matter which by or under this Act is required to be or has been decided or dealt with, or which is to be or has been determined by the controller or the appellate or other authority specified in the provisions of this Act, and no order or judgment passed or proceedings, including execution proceedings, commenced under the provisions of this Act shall be called in question in any civil court. Now, kindly permit me to read section 5 of the Act. incidence of tenancies in respect of lands vested in the state. Now, with this, your lordship will find what is the ambit of the controller. Because the powers of the controller are separately laid down under section 11. But kindly take up section 5, subject to the provisions of the Urban Land Sealing and Regulation Act 1976 and the provisions of this act. Every Thika tenant occupying any land under a landlord on the date of commencement of the act shall occupy such land on such terms and conditions as may be prescribed directly under the state, as if the state had been the landlord in respect of that land. I pause here, my lord. Since it's a Thika property, my lord, after 2001, the property vests in the state. This point was raised when the suit was filed. That today, how can you proceed with the suit when you have not made the state a party? State is not a party. Now today, if there is a declaration sought in void, the lordship is well aware it will be hit by section 34, the proviso under Specific Relief Act. Because today, what they are doing is they are praying for a relief which cannot really be executed. I'll indicate why, my lord.
Is there any relief against the state?
My lord, this is a partition. The property, if it is a Thika property, it has vested in the state. So today, after vesting in the state, how, in my very respectful submission and in a question form, I ask myself, but how can this order of partition be at all executed? What they have prayed for, kindly take up the plaint before I proceed any further. My lord, may I show that the plaint was amended, and I'll show what was the amendment. The first, my lord, the unamended plaint. And I'll read out the prayers in the plaint. The first, my lord, the plaint which was filed, the unamended plaint, the prayer is for a decree for partition, declaring that the plaintiff's 4/9 share, because they had then decided it was 1/9 each, that can't be, in the suit property. So decree for partition declaring, so there's a declaration that is sought for, my lord, with the partition, declaring that the plaintiff's 4/9 share in the suit property. That's the first prayer. Second, for appointment of a commissioner for effecting partition. That's the consequential prayer. And then injunction, accounts, costs. Then they realize their mistake. They file an amended plaint. The prayer in the amended plaint, the first prayer is for a decree for partition, declaring that the plaintiff's 1/3 share in the suit property mentioned in items 1 and 2 of the schedule below. So they bring it down from 4/9 to 1/3, because by then they realize the mistake that it has to be 1/3, 1/3, 1/3. Seek a declaration. Second prayer is for appointment of commissioner for effecting partition in terms of the preliminary decree and final decree based on the commissioner. The usual prayer. Remember, if it is a Thika property which has vested in the state, the second prayer cannot be given effect to without making the state a party. State is not made a party, and this issue was
in
raised.
respect of heritable right,
my lord,
declaration of heritable right, state is not required to be party.
I'm very grateful. If it was only, my lord, a declaration without a consequential relief, that very prayer is wrong.
Now you have to show me that the commissioner under the Thika Tenancy Act has the right to declare the heritable right of any party.
Thika property, my lord, kindly take up. A Thika property
The declaration of Thika tenancy is that the tenant under the Thika tenant is directly come under the state. The right
that's
with the
vesting.
state.
That's vesting. That's
Yes.
5/4.
That is all about. And heritable right cannot be determined by the commissioners. Commissioner,
kindly
there
take
are
up,
other
I'll
powers.
also explain this, my lord, when I come back to the law at the end. But
Yes.
I'll indicate since the question is.
Yes,
put in,
yes,
my lordship.
yes, you continue.
Kindly take up, let me try and answer that, my lord. At the very outset, 5.4.
Yes,
The
5.4.
interests of the Thika tenants holding directly under the state under subsection 1 shall be heritable and shall not be transferable.
Yes.
Except inter se amongst the heirs and existing co-sharers, interest and spouses, or to their prospective heirs with a prior permission. This is very important, my lord. With a prior permission of the controller, subject to the provisions of 6.1.
That is
Controller is not
transfer
a made-up party.
in respect of transfer,
My lord.
the commissioner has the right to pass an order. But in case of heritable right,
Then there is no other, my lord, remedy, because kindly take up section 21. That could not be maintainable at all. The suit is not maintainable. With this prayer, kindly take up, my lord. No civil court shall have jurisdiction to decide or deal with any question to determine any matter which by or under this act is required to be or has been decided or dealt with, or which is to be or has been determined by the controller or appellate or the other authorities. So if, my lord, I can show that the controller has the authority to decide on this with a prior notice.
Yes.
The court cannot look into it. And this was the issue raised at the very outset on the maintainability of the suit. And I'll indicate from the first judgment, my lord, as to how this was dealt with by the court. In my very respectful submission, that dealing itself is wrong. Because today, if it's a Thika property, there is an automatic vesting in the state. Now let us assume for a moment, my lord, that let me premise my submissions with a different, my lord, at the different altar. Today, my lord, if it's a Thika property which is vested in the state, after the vesting, the state is in charge of that property, my lord. Now, if there is a declaration by the court with regard to partition, the partition cannot be given effect to. The partition, my lord, because it's a Thika property. So, there cannot be any effect to the order given by the court. And the court would also not pass an order, my lord, unless I understand, my lord, that today non-joinder of party is not a, my lord, it's not a point which can be urged in Order 7, Rule 11 proceeding. It's a curable defect. But the suit has concluded. The first appeal is over. That stage is gone. The defect was never cured. And I'll also show, try and fortify my submissions through judgments, that
yes,
this particular proceeding, when two properties are involved, one admittedly a Thika property, even if, my lord, there is an admission by the defendants,
yes,
with regard to, my lord, a share in the Thika property, that wouldn't be, my lord, they cannot be held to such admission because there's no estoppel against the law. So if there's a bar in law, you have to proceed with this particular, my lord, proceeding, that could not have been continued with under any circumstances. I am not on the argument which has been advanced, my lord, at the first and the, my lord, at the trial stage and the my lord, first appeal stage. Because the primary argument which was advanced then was with regard to, my lord, how the right has trickled from Bhutimuni Das to Bimala Hajra, the plaintiff. That's not the primary issue. That's an issue, of course. But that's an issue for the other property, 4x1 Shankar Bose Road, where I have, my lord, from the very pleadings and, my lord, the statements recorded, I can show that Bhutimuni Das was never in possession. Today, if Bhutimuni Das was in possession, and if that was the finding, then, my lord, with the recent Supreme Court judgment, I could not have really made a submission. Because in that decision, my lord, it is, the law is called out very clearly that if 37 Act comes in, there is a right of maintenance of the widow then that right will crystallize if the possession is with the widow after the 56 Act. It crystallizes, section 14 has been explained. But that essential ingredient, which is sine qua non to the entire proceeding, possession, is missing. Now, my lord, kindly note, Thika property, I have three broad submissions. One, my lord, it is barred under 21 and 5, a conjoint reading of the Act. Suit is not maintainable.
State is necessary party, but
That's
not
my
joint
second
party.
submission.
Second submission.
Even if state is there, my lord, the first submission is there is a clear bar.
Yes.
The suit could not have been proceeded with. It's a Thika tenancy property, which is, my lord, an admitted position on fact. That's my first submission for Rakaldas Audi Road. My
Yes.
second submission is today, my lord, the state is not made a party in the proceeding. So no order could have been passed in the proceeding, or this issue could not have been adjudicated in the absence of the state. State is both a necessary and a proper party in the proceeding, because it is the state who can come and say, my lord, the status of the vesting. That issue has not been, my lord, addressed. That's my second point. That a necessary and a proper party was not, my lord, arrayed in the parties by the dominus litis. Second point. My third point with regard to Thika property is, my lord, if there is a declaration which is sought for and the declaration is in void, it's a declaration in void, because subsequent part cannot be acted upon. That declaration is hid by section 34, the proviso of Specific Relief Act, and the suit is not maintainable. 3 pointers, my lord, for the Thika property. For the 4x1 Shankar Bose Road property, there's an admission that this is in occupation of the tenants.
Yes.
This is the other property, my lord.
Four by one Shankar Bose.
4x1 Shankar Bose Road property.
Never possessed by Bhutimani.
Never possessed. And when it was possessed, I'll indicate from the recording of the first learned trial court. When it was possessed as a guardian of the minor sons. It was actually for the sons. And by the time, my lord, 56 Act came in, the sons were majors, they were no longer minors. So Bhutimani Das had no subsisting right, was not in possession of 4x1 Shankar Bose Road.
Yes.
If Bhutimani Das was not in possession, if I can indicate that, canvas those submissions and those lines before your lordship, then, my lord, the plaintiff Bimola Hajra cannot claim a right with regard to this property. Because the chain then breaks, my lord. There is no continuous chain then. No right has trickled down to Bimola Hajra. Now, my lord, before I proceed any further, kindly permit me to request your lordship, my lord, to read along with me, my lord, this first judgment. It's the first page, my lord, in the paper book. May I request your lordship to take up page number 2?
Yes.
Page number 2 from the very top, my lord, because that's the facts very briefly indicated by the court. Plain case in brief is that Bhutimani Das was the sole and absolute owner of the suit schedule property who recorded her name in the records of then CMC and remained in possession till her death on April 22, 1971. She died in 1971, leaving behind her the plaintiff as her daughter and 2 sons, Gopi Charan Das, predecessor in interest of the defendant numbers 1 to 5, and Krishna Charan Das, defendant number 6, who inherited the properties in equal shares, that is 1/3 each. Alternative case of the plaintiff is that that for argument's sake, even if the husband of Bhutimuni Das, that is the father of the plaintiff Kalicharan Das, since deceased, was the sole and absolute owner of one of the suit properties, that is 4/1 Shankar Bose Road, the mother of the plaintiff, that is Bhutimuni Das, has got the right to maintenance and a pre-existing right under Shastriya Hindu law, who was in possession of the same and had right, title and interest therein, who after coming into force of the Hindu Succession Act 1956 became the absolute owner of the same. It is also contended that the aforesaid Bhutimuni Das retained the aforesaid property in lieu, but kindly note that it's lieu, of her right to maintenance and also got life interest, which subsequently ripened into absolute interest. Further plain case is that premises 4/1 Shankar Bose Road, but kindly note this, is fully occupied by tenants. It's an admission, my lord. And the defendants deprived the plaintiff from the share of rents of the same, and the defendant, being greedy persons, are trying to raise illegal construction of the suit scheduled property and also trying to dispossess the plaintiff from the suit property with the help of antisocial. Kindly note, this is 10 years back, my lord. In fact, this is 15 years back, 2010. So, my lord, 15 years, I don't, my lord, think this has continued or this has ever happened. Otherwise, 15 years would not be required really. Accordingly, the plaintiff requested the defendants for partition and accounts of the suit scheduled property, but as they did not pay any heed, she filed the instant suit claiming relief as per prayer in the plaintiff. Well, this part deals with the first property. There are two admissions here on facts, undisputed facts, that this is occupied by the tenants and the rent has never been given. Defendant numbers 1 to 3 contested the suit by filing written statement, denied material facts over the page, my lord. Scheduled property cannot be subject matter of this suit. Now, my lord, kindly note, this is the second property. So this is page number 4, internal page number 4 at the top, my lord.
Yes.
Subject matter of this suit as the premises number 32A, Rakhaldas Odi Road, is a Thika property which is totally impartible, while in the premises number 4/1, Shankar Bose Road, the plaintiff is neither the owner nor co-owner or co-sharer. I pause here a minute. So this was a point taken by the defendant at the very inception, that this cannot be a subject matter as it is a Thika property which is totally impartible. While in the premises 4/1 Shankar Bose Road, plaintiff is neither the owner nor co-sharer. It is further contended that in the written statement that Kalicharan Das died in 1935, long before implementation of the Act of 1937, which introduced important changes in the law of succession by conferring new rights of succession on certain female, and before 1937, the simultaneous heirs of a male Hindu dying intestate comprised only the son of the predeceased son, and the son of the predeceased son of the predeceased son. So those are the three. It is further contended that after the death of Kalicharan Das in 1935, the ownership right in respect of premises 4/1 Shankar Bose Road was vested in his two minor sons, names given jointly, absolutely and forever, and Bhutimuni Das had no life interest in respect of the estate of Kalicharan Das, as her two minor sons became absolute owner of the name, and question of ripening her alleged life interest in the suit property does not arise at all. It is further contended that Bhutimuni Dasi had no share in respect of estate of her deceased husband, so her daughter, present plaintiff, cannot inherit any share after the death of Bhutimuni Das. It is also convinced that the plaintiff never requested two defendants for partition. My lord, kindly ignore the spellings, perhaps, my lord. And the defendants never encroached any share of raised illegal construction as claimed by the plaintiff. They prayed for dismissal of the suit. Issues have been framed. Now, kindly note, my lord, First and second is whether plaintiff can present the present suit. Second, whether it is maintainable. Third, whether plaintiff has any right, title, interest in the Thika tenancy property. Fourth, whether the plaintiff is a co-sharer in respect of 4/1 Shankar Bose Road. 5, similar. 6, entitled to a partition. 7, any other relief. Now kindly note the issues. Starts from issue number 3, my lord, page 7. The second paragraph at page 7. But kindly note the first word. Admittedly, the premises 32A Rakhalda Shoddy Road is a Thika tenant property owned and possessed by Bhutimoni Dasi. Since deceased and the present plaintiff as well as defendant 6 and the predecessor in interest of D1 to D5 being the 2 sons and 1 daughter of Bhutimoni Dasi inherited the same after the death of Bhutimoni Dasi on April 22nd, 1971. Further admitted position is that the plaintiff Gopi Charan Das, since deceased, and D2, so the 2 sons and 1 daughter, are the joint owners of the structure standing on the premises Rakhalda Shoddy Road, having 1/3 undivided share each, and also find support in the written statement filed by the defendants. Contesting defendants admitted existence of 1/3. Now, kindly note the admission. Admission is with regard to the Thika tenancy property. That very well there is 1/3 right that she has in the Thika tenancy property. You can kindly take up page 8 at the top. The premises is 32A Rakhalda Shoddy Road. It is contended by them that since the land underneath the structure is vested to the estate as Thika property, the same is impartible. So the admission and then the contention that very well even if she has the right in this property, it cannot be partitioned. Be it mentioned here that though the contesting defendants admitted the plaintiff's 1/3 undivided share in the structure standing over the premises in the written statement, DW1 denied. And this paragraph, my lord, is that even if you deny, it is beyond pleadings, you cannot deny. That's the next 2 paragraphs. So the effect of these 2 paragraphs is, even if it is denied, it is the admission stands that 1/3 share she is entitled to in the Thika property, the plaintiff. That's an admission in the proceeding by the defendants. By the defendants. Now kindly take up, my lord, page 9. The first paragraph says you cannot deviate from the admission made. We agree, my lord. Moreover, there is nothing on record. It would not be regard, my lord, it would be record to show that the property, though purchased in the name of Bhutimoni Dasi, consideration money of the same was paid for by her husband. Now kindly note the next paragraph. At the time of hearing the argument, lawyer for the defendants argued that since the land of the premises number 32A Rakhalda Shoddy Road belongs to the state, but kindly note this argument. It was made in the trial, in the suit proceeding. Belongs to the state, which is a Thika property, and since Thika controller has not been made a party in this case, the aforesaid property cannot be partitioned in view of the prayer of the plaintiff. I pause here for a moment. Now, this is perhaps the reason why, my lord, when the second appeal was admitted in the year 2010, the issue of maintainability was kept open as issue number 3. It's an egregious, my lord, error in judgment. And I'll indicate, my lord, how this has been dealt with. On the other hand, learned counsel for the plaintiff has argued admittedly, plaintiff has 1/3 undivided share in the property. She is entitled to get partitioned and not impleading Thika controller over the period as a party in the suit cannot be an impediment in granting relief in favor of the plaintiff, as the Thika controller is not at all a necessary party in the suit. Since 1/3 undivided share of the plaintiff in the structure of the premises number 32 is admitted by the contesting defendants, the only question required to be determined is that whether not impleading Thika controller as a party in the suit can debar the plaintiff to get the aforesaid property partitioned. That was an issue which was not considered by the court. In this regard, I would like to mention here that the persons having right, title, and interest in the structure lying over the premises are necessary parties who have been made parties in the case, and the Thika controller cannot be a necessary party in such case of partition. And so, in my view, not impeding the Thika controller cannot be an impediment in granting relief in favor of the plaintiff. I pause here, my lord. Had it been only a declaration, my lord, this would be different. Today, my lord, it is to be looked into as to what is the stage of the vesting. If it is vested in the state, partition cannot be given effect to. Now, kindly see how it is proceeded with. In this regard, I would further like to mention here that since the land underneath the structure belongs to the state, so this has been considered by the court. The question of partition of the same does not arise at all, but the structure standing thereon, wherein the plaintiff has 1/3 undivided share, can easily be partitioned amongst the co-sharers. And in my view, there is no impediment to do so, and the plaintiff has rightly claimed for partition of the same. So there is a distinction that has been created, my lord, from the structure and the land. And I'll indicate, my lord, in law that distinction is not permissible for a Thika property. If that distinction is to be made, it can be made in certain circumstances. I'll indicate the flow of law and the genesis of the Thika Tenancy Act, my lord, very briefly in 15 minutes to indicate why this observation of the court is bad in law. And thereafter, my lord, the finding is the aforesaid issues is accordingly decided in favor of the plaintiff and disposed of. So that's a part which, my lord, has gone against the defendants. Now, my lord, kindly take up 4 and 5. That's more important because, my lord, the Thika tenancy part, perhaps, my lord, is the more prominent part which could not have been considered by the court. That's the part which has been held against the defendants. Even if there is an admission which is recorded that the defendants in their written statement have admitted to 1/3 share, which they cannot renege from now. They cannot walk back. But that admission, my lord, if it is different in law, there can't be an estoppel against law. But if it is a stand which I can, my lord, establish through the law and the judgments, that this part could not have been considered by the court. This issue could not have been looked into by the court without, my lord, making the Thika controller or, my lord, the state a party to the proceeding.
Okay.
And the same point was urged in trial. Now, issue number 4 and 5. This is for the other property. Premises 4/1 Shankar Bose Road. Plaintiff's contention is that Bhutimuni Dasi was the absolute owner of the same, who recorded her name with CMC records and remained in possession till her death. And so after her death, the plaintiff deceased Gopi Charan Das, Krishna Charan Das inherited the fruit property. In this regard, plaintiff relied on Exhibit 3 series. Alternative contention of the plaintiff is that even if the husband of Bhutimuni Das was the owner of the same, Bhutimuni Das has got the right to maintenance and a pre-existing right in the said property, who was in possession of the same, which after coming into the force of Hindu Succession Act became absolute. This was the argument, which I started with. That perhaps if this argument is made only, then I will not stand a chance. But this is not the only argument. And the fallacy in the argument has also been noted. On the other hand, contention of the contesting defendants is that the aforesaid property was the absolute property of Kalicharan Das, who died in 33. Kindly ignore the date 33, 35, it's the same because the act came into force from 37. And as per provision of the Hindu Succession Act prevailing at the relevant point of time, the property vested to the minor sons of Kalicharan Das. They are named, noting in the same, the plaintiff cannot claim anything in the aforesaid suit property.
Yes.
In this regard, defendants relied on Exhibit A. Admittedly, now kindly note, this is the finding of the court. Page 12, the last paragraph. Admittedly, Bhutimuni Das died in 71. Kalicharan Das died in 35 before implementation of the 37 Act. True sense, Bhutimuni Das got nothing on the death of the husband in the year 35, as she was not entitled to get anything in view of the existing laws of succession at the relevant point of time. So far, Exhibit 3 series is concerned, I would like to mention here, kindly note this, my lord, that the same is a copy of an assessment book of the CMC which cannot confer title to Bhutimuni Das in respect of the premises, and there is no scope to hold that Bhutimuni Das was the sole and absolute owner of the same. On the other hand, Exhibit A, the title deed in favor of the deceased Kalicharan Das, which shows that the aforesaid Kalicharan Das was the absolute owner of the same, having right title interest therein. I find nothing on record to disbelieve the authenticity and genuineness of the said title deed. Since it has been made clear that Bhutimuni Das was not the sole and absolute owner of the aforesaid property, rather her husband Kalicharan Das was the owner of the same. Now the question arises whether Bhutimuni Das has any right title interest in the said property. But this is the issue which is framed. But kindly note this. This is where the issue is framed by the court. Over the page, property after the death of Kalicharan Das in the year 1935. Plaintiff's contention is that after the death of Kalicharan Das, Bhutimuni Dasi occupied and possessed the aforesaid property till her death towards the right of maintenance, which is a pre-existing right, and so the present plaintiff is entitled to inherit the same, as her such right has become absolute after coming into force of the Succession Act of 56. This is the argument which was made by the plaintiff. Now kindly, my lord, note how it is dealt with by the court. In order to prove possession of Bhutimuni Das, the plaintiff relied on Exhibit 3, that is the assessment book of KMC, my lord, which reveals that the name of Bhutimuni Dasi has been recorded therein as mother. But kindly note this part. How is it recorded? As mother and natural guardian of minor sons of Kalicharan Das. That is Gopicharan Das and Krishnacharan Das. It is crystal clear from the aforesaid documents that she possessed the property on behalf of her two minor sons who became major prior to coming into force of the Hindu Succession Act. This is very, very important. So Bhutimuni Das was holding the property as a guardian of the minor sons. Before the 56 Act, the minor sons turned major. There is also nothing on record to show that Bhutimuni Das possessed the same till her death and possessed the same towards her right to maintenance. I pause here for a moment. This is a finding of the court. And why this is very important, I'll also indicate, I'll digress, kindly permit me to digress for a moment. The first appeal, my lord, is not on this point, because this point, as your lordship, my lord, has understood, this is the point, my lord, which is held in our favor for 4/1 Rakalda Sodi Road. Thika property point is held against us.
Yes.
By the learned trial court. In the first appeal, this genesis of the law after death in 35, the 37 Act, and how 56 Act comes in is, my lord, the thrust of the first appeal. This part is, my lord, not really dealt with, and I'll indicate how, my lord. This part, my lord, shows that possession was never with Bhutimuni Dasi. Page 15, the second paragraph, it is clear from the materials available on record that after the death of Kalicharan Das in the year 35, his two sons inherited the same, but since they were minor at the relevant point in time, the name of Bhutimuni Dasi, being the mother and natural guardian, has been recorded in the record of rights. In my view, the plaintiffs cannot claim any right title interest in the suit property on the basis of such recordings in the CMC records, as Bhutimuni Dasi got nothing in the aforesaid property on the basis of records in the CMC, as her name got reflected therein just because sons of Kalicharan Das were minor at the relevant point of time. Bhutimuni Dasi certainly has some right, title, and interest in the suit property, and the plaintiff can also have claim therein if the plaintiff would have been able to establish that deceased Bhutimuni Dasi, kindly mark this part, my lord, occupied the aforesaid property as her own after acquiring some sorts of interest therein. That's where, my lord, that is the point which is to be decided. Since the trial court, my lord, is the master of facts, the recording there is, my lord, that there is nothing on evidence to show that Bhutimuni Dasi was in possession of 4/1 Shankar Bose Road. Then, my lord, page 16, But since it is clear from the materials available on record that Bhutimuni Das occupied the aforesaid Shankar Bose Road property on behalf of her two minor sons who attained majority before coming into force of the Hindu Succession Act, I am of the view plaintiffs cannot claim any right title interest in the aforesaid property in which Bhutimuni Dasi herself had no right title and interest. In the absence of any cogent and reliable evidence on record, there is little scope to hold that deceased Bhutimuni Dasi retained possession of the aforesaid property till her death towards her right to maintenance, and in the given circumstances, I am of the opinion that it would not be safe to rely upon the version of the plaintiff regarding right title and interest of Bhutimuni Dasi over the aforesaid Shankar Bose Road property. However, PW1 cross-examination has stated he can't say how Bhutimuni Dasi became the owner of the Shankar Bose Road, and evidence of DW1 remain in fact in spite of lengthy cross-examination, which was nothing more than an evasive denial. In view of all the above noted facts and circumstances, it can safely be said that since the deceased Bhutimuni Dasi had no right title interest in the Shankar Bose Road property, the present plaintiff cannot also have a right title and interest wherein the aforesaid two issues are accordingly decided against the plaintiff and disposed of. I pause here, my lord. This is very important because this is with regard to the property which is, my lord, tenanted. The only issue here is whether Bhutimuni Dasi was ever in possession. If Bhutimuni Dasi was not in possession, the plaintiff can have no right. And on the evidence, on the facts, on the, my lord, evidence adduced by the plaintiff, this is the finding of the trial court.
Yes.
The error, my lord, is thereafter issue 1 and 2. It appears to me suit is it shouldn't be nil, well maintainable. You know, this is page 17, my lord, under issue 1 and 2. The third line. Well maintainable in its present form, and plaintiffs also have a cause of action to file the same. So, my lord, it is not Order 7, Rule 11, D which was being filed, or my lord, A which was being considered. The issue was Thika tenancy, which is not, my lord, really considered. The lordship will note, my lord, there is no, my lord, contention recorded with regard to the provisions. 21(5), how, my lord, the controller has this right, you cannot really look into it, nothing gone into.
Yes.
Issue 6 and 7. So far as these issues are concerned, I would like to mention 4 and 5 has already been held. Plaintiff has no right title, page 18. No right title interest in premises 4/1. While deciding issue number 3, it was held. Has 1/3 right in Rakaldas Audi Road. Accordingly, I am of the view plaintiff is entitled to get partition only in respect of the structure standing over premises 32/A. Not entitled to, this is the finding. With this, my lord,
decreed in part.
Decreed in part in our favor, because Thika tenancy against us, saying that 1/3 you have admitted in the written statement, without considering, my lord, the bar in law, without considering those 3 broad points, my lord, which I have submitted. And, my lord, the other property, the tenanted property, is held in our favor because there was no possession ever. That was the, my lord, moot point.
Yes.
Lord, my learned friends, Lord, they then preferred an appeal. So the first appeal, may I request your lordship to take up page 25. But, my lord, because since I intend to make this submission with the judgments and conclude, may I then come back on the next day and, my lord, I'll indicate this judgment, the relevant portions of this judgment, and why this is not sustainable in law at all. The, my lord, formulations of law which I have, my lord, placed before your lordship today, I'll place judgments, 1 judgment each, not more than that. I'll not trouble your lordship with, my lord, the avalanche of judgments. Maybe in the total, my lord, 3 to 4 judgments I refer to on different propositions. My lord, I'll conclude. My submission still would remain, my lord, that Thika property, my lord, the issue could not be considered by the suit court. It's an order, my lord, which is an order which cannot be implemented at all. The other point, my lord, which has been held in our favor and which, my lord, did not find favor in the first appeal, is also, my lord, ill-found, because there, my lord, the genesis of the entire order in the first appeal is the flow of rights from 35 to 56. The my lord, moot point decided was that the right percolated and there was no breach there was no break in the continuity of the right. So if there's no break, then the mother Bhutimuni Das had the right. It crystallized under section 14 of the 56 Act. And then, my lord, it trickled down to the plaintiff. The plaintiff is entitled to it. Hence, the outcome that if the plaintiff is entitled to it, the trial court erred in not giving it, granting it to the plaintiff. That's the finding.
Yes.
In the process, my lord, I'll also indicate the recent two judgments of the Supreme Court. One, my lord, very recently, because I'm sure my learned friends will indicate and rely on those judgments. I'll first show how that is not relevant in the facts of this case because of the findings of the trial court. Those findings still remain. And I'll indicate why, my lord, the first appellate court has not touched upon those findings. And hence, the Supreme Court judgment is not an impediment at all in this proceeding. And I'll fall back on the reason, my lord, why the maintainability of the suit was kept open while admitting the second appeal. It's a point of law, my lord. There's no impediment in making these submissions. I'll
Can
do
we
so
take
and
it
I'll
again?
conclude in half an hour. Will not take more time, my lord.
Okay.
May I only request your lordship, if, my lord, since it is fresh in your lordship's mind, my lord, may I come back on next Tuesday?
Next Tuesday is the day.
Next Tuesday.
Argument on behalf of the appellant heard in part. Let the matter appear in the list on 10th of December at 2 p.m. 2 p.m. So 2 p.m. is up.
Very deeply obliged, my lord, for the patient hearing. Very deeply obliged.
I am grateful. ওইটা দিন। Four and five urgent. Urgent cover করতে বলেছে কার 10th 4 and 5 10th. Next call next matter.
For the petitioner, my lord, filed affidavit of service. In this matter, my vacancy notification has been there, my lord. Annexer P4, page 15. Page 15, serial number 40. And memo I have stated in paragraph 5. Within the area Paramanandapur and adjacent villages. Where the petitioner has been running her fair price shop for long. Memo number 221, MRTFS 24.
Where is the license?
And license is that, my lord, page number. Page number, my lord, 30, 13.
Page number 13.
Next repeat.
Village Paramanandapur.
Paramanandapur and other adjacent villages having the units there, including all. A serial number 40 is, my lord, memo dated, my lord, 28th May 2024, memo number 221. Kumarara. The new vacancy within the area of the
Is the location of the vacancy is Kumarara.
My lord, Kumarara.
Kumarara.
Kumarara. New vacancy within the area of the petition.
Petitioner is distributing the ration articles in this area.
My lord.
Whether you have
They
pleaded that.
are curtailing the units from the petitioner and going to fill up the vacancy which is newly created in the area concerned, for affecting the right and interest of the petitioner. And my lord has held view, my lord, in respect of that matter, the pendency of the appeal before the Honorable Division Bench.
Judgment tenants.
So the problem is there. Yesterday also your lordship had
Judgmental copy tenants. Judgmental copy tenants. Similar order copy আছে.
আচ্ছা
Yes.
in other cases your
I
lordship
believe
has
lordship has found his opinion.
okay. Within the block, my lord, Nando Kumar. Page 15.
Please take down. Vacancy notification. Vacancy notification. Vacancy notification. পেয়ে যাবেন ঠিক আছে তাও বলে দেবো চট করে নিয়ে নেবেন ছোট্ট বলো তো ভেরি 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 affidavit of service filed on behalf of the petitioner is taken on record. The present petitioner is a MR dealer who is performing his business over the area Mauja Paramanand over the area wherein the concerned respondent authority has issued a new vacancy notification VDA memo number 221
Yes, my lord.
oblique MR
40
oblique TFS oblique 24 dated 28/5/2024. Full stop. It is the case of the petitioner that he is performing the business in an unblemished manner, and if such notification, if the new notification is filled up, her business would be economically viable. The petitioner also challenged the issuance of new vacancy notification in law which was published by virtue of WBPDS control order WBPDS within bracket M and C order 2013 control টাকে M and C মানে maintenance and control 2013 heard the learned advocate peruse the license issued in favor of the petitioner, also peruse the notification issued by the concerned respondent authority. It is true. No, the petitioner had challenged the legal aspect that after promulgation of National Food Security Act 2013 and Targeted Public Distribution Control Order 2015, WBPDS within bracket MNC Order 2013, on the basis of which impugn notification was published, became redundant. Full stop. Next para. The issue raised in the instant writ petition has also been raised before the Honorable Division Bench in a batch of appeals being MAT 1543 of 2024. Full stop. It comes to my notice that the Honorable Division Bench has already passed and directing the concerned respondent authority not to delink any of the ration card holder from a dealer till further order. Full stop. Learned counsel appearing on behalf of the state respondent raised strong objection and submits that the issue involved in the writ petition is not apropos same to that of the issues raised before the Honorable Division Bench. Having heard the learned counsel for the parties, state respondent is at leave to file affidavit in opposition within 2 weeks after vacation. Full stop. Reply if any by the petitioner within 2 weeks thereafter. Considering the facts and circumstances of this case, next paragraph. Considering the facts and circumstances, and also considering the presence of an order, presence of an interim order passed by the Honorable Division Bench, I think it necessary that the present petitioner deserves the similar order. Deserves the similar order. Similar interim order. Hence, it is ordered that the respondent authority is at leave to proceed with the selection process, but so far as the issuance of license, issuance of fresh license is concerned, that shall not be commissioned till the disposal of the appeal pending before the learned Division Bench, being MAT 1543 of 2024. Let the matter go to the list. Parties are relieved to it. Grateful to your lords. Next.
33, my lord, same block. Only the vacancy notification by memo dated, my lord. Memo dated 29th May 2024, serial number 37, page 15, and the license is at page, my lord, 13. Only the Mouja is the Jalpai. 37. Mouja Jalpai near Ponchanon, Adarsha Vidyapit, SST. Page 15.
Serial number.
Page 15, serial number 37.
Serial number 37.
224 memo.
Memo number 224. Memo number memo number 224 stroke MR stroke TFS stroke 24 dated 29th May 2024.
Jalpai near Panchana Adarsha Vidyapit. And my fair price shop is located, my lord, Bagdoba Jalpai. within the same mauja. Page 13, P2. And there, my lord, that is, there a memo dated 20.
Okay, similar direction. Similar direction.
Yes.
দেখেন এখানে মেমো নাম্বারটা শুধু চেঞ্জ হবে, আর তো কিছু চেঞ্জ হবে। কোথায় বলেছি আমি এরিয়াকে আগে বলেছি? দেখুন তুই আগে তো বলেছি, পরমানন্দপুর বলেছি। ফার্স্টে দেখুন পিটিশনের এই যে এমআর ডিলে ফার্স্টে না বলিনি, এরিয়া বলিনি, ইচ্ছে করেই বলিনি, কারণ গন্ডগোল হবে। ঠিক আছে,
Up to 39, my lord. Same identical order, my lord, same block, Nandakumar, only memo is changed and subject.
just wait, let me take out one after another.
As your lordship.
Give me next matter.
Next matter, 34, my lord. Here, my lord, memo number 248, serial number 14. 14. Page 15. 248, serial number 14. Also Jalpai. Having there the fair price sum of the petitioner, Bagdova Jalpai. Serial number 14248, MR TFS 24, dated 29th May 2024.
Serial number?
Serial number 1414. Left hand side, my lord.
Memo number 248.
248.
And দেখুন memo number 248 stroke MR stroke TFS stroke 24 dated 29th May 2024. You are appearing this matter?
Fine.
Affidavit of service charge, static service. Similar direction.
My lord has directed the state to file report.
Yes.
My lord.
35, my lord, same floor. Here, my lord.
নিচে বসুন, নোট করে নেবেন।
Page 4, paragraph 5.
35, I appear on behalf of the state, your lord.
Annexer, my lord, page 15, serial number 18, 18. 18, left hand side, 18, 245, memo. Page 15.
No.
Serial number 18. Left hand side, your lordship, page 15. Annexer P4.
Vacancy location at Jia
29th May.
Jia Khali.
29th May. No. 18.
18
18.
Mauja Baharampur.
Baharampur, near Baharampur ICDS.
Same location.
Number 18, memo number 245, stated in paragraph 5. Same location. The units of the area have been tagged to the fair price sum of the petition. And now they are going to cut the same and to fill up the vacancy of the new MR dealer in the area. For curtailment of the units from the. That is the desire of the state government. And now the Duare ration, my lord, it is distributed Duare ration, my lord, going to the spot, they are distributing the same.
Now, how can you
Not coming
say
to
that?
the fair price shop.
What is the number of DRCs?
My
with
lord,
you?
serial number, my lord, 18. Left hand side.
What is the number of DRCs with you?
DRC number,
How many DRCs are there with you?
my license number, my lord, your lordship is
How many ration card holder is there with you?
ration card holders, my lord, that is there, my lord.
How many
6, 5, 5.
beneficiaries are there?
5, 6, 5, 5.
5,
At the bottom right side.
5, 6, double 5.
5, 6, double.
Very good.
Right hand side, page 40.
Item number 18.
18, serial number 18.
Please take down. এটা নিয়ে নিন না আপনি সেম ইস্যু শুধু মেমো নাম্বারটা নিন তাহলেই হবে আর লাগবে না মনে নিন আইটেম নাম্বার 18 মেমো নাম্বার 245 স্ট্রোক এমআর সিমিলার ডাইরেকশন
36, my lord. Same block, page 4, paragraph 5. Memo number 246.
গরম লাগছে তো এসে চলবে না চালাচ্ছ না কেন বেশি
Date, my lord, 29th May 2024. Serial number, my lord, 19.
My lord, I am appealing for this.
you are appealing for the state
Yes, my lord, item 36.
Serial number 19. Right to my left hand side. Memo number 246. MR TFS 24. Dated 29th May 2024. Samsundarpur, near Samsundarpur, Kalimondi.
memo number 246
246.
MR
MR.
TFS
My lord.
Okay, similar direction. Get to file affidavit within 2 weeks after vacation.
Very good.
Reply, if any, within 2 weeks thereafter.
37, my lord. The same issue. Here, my lord. Memo. But number 211. 211, serial number 48. Memo dated 28th May 2024, paragraph 5, page 4.
Serial number 48.
48, 211. Serial number 48. Serial number 48. Page 50. Page 50. Rajnagar. 211 MR, TFS 24, 28 May 2024.
Mr. Chatterjee, are you there?
Yes, my lord.
Ration card holders, my lord, 5655. Page 14.
Okay, similar direction. Next.
38, my lord.
I am for the petition. I am for the statement.
Here the memo is changed. The memo number 220. 220 MR TFS 24, dated 28th May 2024, serial number 41. Page 15. Bhavanipur, Mauja Bhavanipur.
Serial number?
Serial number
41.
41. Memo number 220 MR TFS 24, dated 28th May 2024. So card holder সেখানে
Okay, similar direction.
39 also the same, my lord. Here,
And I am for the state lordship.
the block, my lord, Agra. Block Agra instead of my lord Nanda Kumar. Agra block 1. Here memo number paragraph 5, page 4. My lord, I am sorry to say, my lord, because the notification
Center location Sharat Kumari SSK.
my lord. Here the my lord page 15 annexer P3 total units 8581. Page 15 annexer P3.
Sanjay Giri. Sanjay Giri na ko?
30th May. Page 16, my lord, annexer P4. Vacancy notification.
Memo
Left-hand
number.
side at the top.
Memo number.
Memo number 251.
251.
EFS stroke 24 dated 30th May
2024.
Page number 16, annexer P4. Annexer P4.
Okay, similar direction.
Lordship,
Grateful.
state has given me on report regarding this matter, Lordship. May I file the report, Lordship?
Yes, give me the.
No.
Your DRCs are more than 10,000.
Yes, Lordship.
So after dealing, his DRC would be 5,602. ওই যে বলেছি না state submitted that the issue এখানে বলছে issue involved in the writ petition is not apropos with the issue involved in the writ petition বলেছি না ওইখানে করা যাবে state has also placed a report.
Present population lost 11,497, Lordship. More than 10,000, Lordship. Come to Lordship. Point number 5, Lordship. On the first page.
Okay. কি বললাম বলো? Step report containing inter alia that the present that the petitioner is petitioner having DRC population at present is 11,497. He is now serving a huge area.
Yes, Lordship.
So for betterment of distribution of PDS, the area and the population of PDS need to be delinked. Okay. Similar
Copy
direction.
of the report may be handed over to me for my lord
Lordship,
going through the
how
same because I do not know what is there, my lord.
copy of the report
Copy of
in this stage? Why it is necessary?
Yes. Grateful, Lordship.
They are directed to file the affidavit in opposition within 2 weeks.
My
there.
lord, my lord.
Grateful.
Similar direction. Hmm, hmm, hmm. 40 not this week করা আছে? ঠিক আছে ঠিক আছে।
Lordship, in 41, I am appearing for Indian Oil Corporation.
Yes.
Affidavit of service.
Respondent number 2 to 6, 2 to 5.
You are for the respondent number 2 to
2
5.
to 5.
Lord, Lord, international, may I please your lordship?
Private respondent number 6. Yes. What is the matter about?
Lord, in a nutshell, may I appraise your lordship? Now, my lord, the petitioner was a landowner in Purbo Bardhaman. Now she intended to start a business of petrol pump, for which she converted the land for the purpose of running a petrol pump. Thereafter, she entered into a partnership with the respondent number 6 and applied for dealership before the IOCL. Now, my lord, considering all other aspects, including the ownership of the land and other documents regarding eligibility and other, my lord, the letter of intent was issued in favor
of you.
In favor of the partnership.
Partnership.
Now, my lord, thereafter, my lord, the business started. The petitioner used to run independently.
You say letter of intent was
issued thereafter.
License was issued.
Dealership was granted.
Dealership license granted.
Agreement was entered into.
And
accordingly, the dealership
business started.
Now, while doing the business, my lord, there was some dispute. The private respondent gave a letter of surrender of the partnership. Deed of retirement was entered.
Yes.
Though it was not informed to the IOCL. That is a latches on the part of the petitioner. Now, the petitioner used to run the petrol pump independently. Subsequently, my lord, the IOCL came to know of the fact that it is being run in an individual capacity. My lord, they gave a show cause notice, we gave a reply. And because there was a change in the constitution of the agreement, my lord, because it could not have been changed from partnership to proprietorship, my lord, the license dealership was cancelled. My lord, the dealership was cancelled, for which, my lord, the petitioner came before this honorable court, but the writ petition was withdrawn. Now, my lord, thereafter, my lord, the petitioner made an application for reconsideration of the grant of dealership independently, individually in the name of the petitioner, since the earlier license was cancelled. Dealership was cancelled. And she being the owner of the property, she wanted to run the business independently. Now, my lord, your lordship knows when the petrol pump is established, my lord, the infrastructure is required. The underground reservoir, this for the storing of petrol and diesel, all these things. Now, it is under the Kisan Seva Kendra. The IOCL has given this dealership under this category. Now, my lord, she applied afresh for grant of dealership independently. Now, that was not considered, for which we came before this honorable court. We made a several representation. Apart from that, my lord, there is one catch. The government has notified that once the land has been converted for using it as a petrol pump, it cannot be reverted back to any other purpose. It cannot be used for any other purpose. Now, my lord, I became handicapped because I had already converted it into a petrol pump. Now, it cannot be reverted back to for any other purpose, for any other business also. And secondly, my lord, the entire infrastructure for running a petrol pump is already intact. Now, my prayer before the IOCL was to consider, since the earlier dealership in the name of partnership has been cancelled, so consider my application afresh, because it can always consider to grant dealership in an individual capacity also.
Where is your representation?
My lord, kindly come to page 163 and 174. 163 to 174. Very innocuous prayer, my lord, for a direction upon the IOCL to consider in a pragmatic manner. Kindly see the subject matter of the representation at page 163, my lord. Issuance or issuance of a fresh dealership and execution of a fresh dealership agreement exclusively in favor of the undersigned in relation to the existing pump Kisan Seva Kendra. Now, my lord, kindly see another notification. My lord, kindly come to page 161 and 162 first. My lord has got it. Page 161 and 162. My lord has got it. My lord will see. It has on the subject direction as per the provisions of section 135(1) of the West Bengal Town and Country Planning and Development Act 1979 to preserve the existing land use of the vehicle refueling stations. My lord, order number such and such. Sir, madam, with reference to the, I am directed to forward here with the order, white memo number such and such, dated 2nd of July 24, regarding direction as per the provision of section 135(1) of the West Bengal Town and Country Planning Development Act to preserve the existing land use of the vehicle refueling stations. You are kindly requested for taking necessary action for the purpose of implementation of the said order. Now, my lord, the next page is the order.
Yes.
Whereas it is observed that there is a tendency of change of use of land pertaining to petrol pumps in other uses for other uses, and whereas the public interest, it is necessary to preserve the existing vehicle refueling stations. Therefore, in exercise of power conferred by subsection 1 of section 135 of the West Bengal Town and Country Planning and Development Act.
Yes.
My lord, your lordship has got.
Yes.
So, my lord, otherwise, my lord, I will be prejudiced. I have no other evocation to do. This is my only source of livelihood.
Lordship, I oppose this prayer. Lordship, kindly appreciate. No government order has been challenged by this writ petition. So, invoking determination of Group 8 is not under the purview of this writ petition. Petitioner has not challenged any government order. Lordship, there was a termination order. Termination letter.
They have not challenged the order.
They initially have challenged the order. Thereafter, withdrawn on the ground that they will file arbitration application. They will go. They will proceed for arbitration in
Altogether
terms
separate issue. It is not
separate issue. That arbitration they have not proceeded with.
Order maybe.
And Lordship, in respect of this, has been submitted by the petitioner that why his dealership was terminated. There was absolutely a suppression. Lordship, kindly come to annexure page 3. Annexure at page 3. Annexure P3. Lordship, at page 23. At page 23.
Page 23.
23, 2-3. Lordship, kindly comes to the right hand side top, the date of the LOI. Date is 8th January 2023.
Issuance of LOI.
LOI.
Letter of
intent.
Yes.
This was, Lordship, issued to Ganesh Chandra Naik, Mrs. Jannavi Kundu.
Yes.
In 2013. Lordship, annexure P2, if your Lordship looks into, this is a proposed partnership deed. At page 18. At page 18.
Yes.
At page 18 is a proposed partnership deed. Lordship, based on this proposed partnership deed, this LOI was issued.
Yes.
Kindly Lordship turns to annexure P4. Lordship, this is the deed of retirement. Retirement at page 26. Kindly peruse the date of this deed of retirement. 12th day of the month of July, year 2013. Immediately after issuance of LOI, this date of retirement was entered into between the petitioner and private respondent. Thereafter, Lordship, dealership agreement was executed. Kindly comes to page number 30. Page 30.
30.
Lordship, this deed of retirement was executed at page 34. 13th June 2014. Your Lordship will get the date at page 34. 13th June 2014. After this deed of retirement, and with whom this deed of this agreement was entered into? Jannavi Kundu and Sri Ganesh Chandra Nayak. Lordship, admittedly, after the execution of deed of retirement, this agreement was entered into between the petitioner partnership firm and with the Indian Oil Corporation. When this agreement was executed, it was absolutely suppressed that prior to this deed of retirement was executed.
So you have correctly
Lordship, we have terminated our
They have not challenged your correct.
not challenged. Lordship, there is no scope to look into their representation because
Then you reject the representation.
Lordship, I have to take instruction whether I have because your all Lordship knows unless and until there is any notification of allotment of new filling station is there, we cannot entertain any application for any appointment of any dealer or like that. Lordship,
No, you have to act according to the brochure. Okay. So you can reject it. No issue. But why you not reply the notification, reply the representation?
Lordship, kindly allow me to use opposition and instruction. I will come back with the instruction. What will be our stand?
Yes, you can come with instruction, no issue. But you have to deal with the representation of the private individual, being a state.
And also, you also kindly allow me liberty to file opposition.
I can allow you to file liberty, but they have now have very innocuous prayer. They want a decision. You may allow it, you may reject it.
Lordship, I understand your Lordship.
Yes.
Lordship, kindly allow me
Not
to
the issue to be entered into now.
Yes.
Lordship.
Whether you have correctly, they have not challenged your decision. Any of your
No, this is not the. I have
whether they are entitled to get the license or not, that is only solely your decision. According to the law.
That based on some criteria.
Yes.
That is based on criteria.
Require some criteria to fill up.
And Lordship, I have to bring those criteria before your Lordship. Lordship, whether we will be what will be our stand?
Right.
Otherwise,
You not
this
challenging
court
the
has to
decision
this
of
court has to pass the order. If you file the opposition, that would be again binding upon you. I left it you decide the
I will
matter.
come with the instruction. Come back.
Very well. Come on the next week.
Lordship, not next week. I have a marriage in my family. Kindly thereafter.
Milord, what are you submitting subject to your lordship's consideration, Milord?
No, I shall hear it out. No issue.
I'm going to 5 to.
So you want 2 week to come accommodation?
Lordship, 2 weeks. I will be available. Lordship. Week starts with 15th. 16th.
In that week, I will be in disposition.
17th will be.
Very well, I'll fix the date. Let me hear the private respondent. Yes, private.
हाँ अच्छा अच्छा
One system. Right. And just we submitted by
Right.
However, that there is an application. The people of the application for of a demand. He is not placed, but the application and the that is one of contract. If so, that the application completed. Now our application has been
No.
they have withdrawn the
Consideration.
the ground that compromise is going. Right, 2013, my lord, he said the cancellation of.
So now there is no reference.
There is no reference.
There is no reference in
reference.
good
No
arbitration.
reference.
Order of my lord, where is an admission on the part of that we intend to compromise with the party.
Look, today petitioner is very innocuous prayer.
That's
He has
what
filed. No,
only
only bar for the prayer is that whether he is coming with clean hand or not. That is the only bar. If he come with the clean hand, he can pray for any representation before the state authority. State authority may reject it.
Any my lord, the proprietor, not proprietor. This was the fake document, my lord, he has stated, admitted that.
Then why you sign the agreement with the state after termination of the business? Why you sign it? You have also signed.
It is why my lord, one page, 130, my lord.
That is altogether separate issue. I have to hear the IOCL. So when can it be fixed? To
That's it.
come with representation? To
70
come with the instruction also.
instruction. See, after 17th any day. After 17th receive.
Next week.
After
Miller, subject to what my learned friend submits, Miller, may I say one thing, Miller? I am not against the private respondent. I am not against the IOCL. I simply want my representation. Let them reject it. There is no question of giving any
I understand.
instruction to my lord.
I understand. I understand.
Only that much. Unless unnecessary the period is the issue is delayed. Even
No.
if they have a right, I'm not challenging the authority also. They have a right to reject my representation.
That is not the issue of this writ petition also.
Yes.
So that is not the matter whether the IOCL wants to come with some report or instruction. So they may be allowed, no issue. Come on 23rd. 23rd.
But can it be last day?
Not last day. 24 is the last day.
It is the last
to
day.
the last day.
23rd and 24th is a busy day for this court, you know.
Let everybody.
Okay, please take down.
But I'm for the Union of India, Malad. We have nothing to say, Malad. Because
You are for the Union of India.
IOCL is answering this point.
Okay. Petitioner filed this writ petition with a innocuous prayer that his representation with the respondent authority being respondent number 225 dated August 14th, 2024 may be considered reasonably. Full stop. The learned counsel appearing on behalf of the IOCL seeks accommodation to demonstrate the matter before this court with some instruction. Full stop. Private respondent as well as the Union of India is represented through their learned counsel. Full stop. Let the matter appear in the list under the same heading on 23rd of December 2020.
Get forward.
Affidavit of service file on the disability.
42, I appear on behalf of the state, your lordship.
My fair portion of license has been terminated without disclosing any reason in the order of termination. I prepared a first appeal, giving the entire details. First appellate authority did not give a single line reason. Then second appeal, also no reason. Principle of natural justice violation. It will also kindly straight away come to first violation, page 30.
ये ऊपर वाला दीदी का है।
The inquiry has been conducted in the doorstep of the consumers, not in my fair price shop. I have no knowledge. No document has been supplied to me, neither the copy of complaint nor the inquiry report. Page 30 is the show cause notice. You will also kindly read the first paragraph. Is it your third? Did not go through the entire because I am on principle of natural justice. You will also kindly turn to 12 cases has been referred. Page 31 and 30. Kindly see 12 cases has been referred. These 12 persons has lodged complaint against me out of 607,000 ration cards. 12. My license has been suspended and I have been show cause. Page 31, last paragraph. Kindly see my reply at page 33. Each and every allegation has been dealt with supporting document. It starts from page 33. It will also kindly start up to page 34. Third paragraph, I came to learn from the state super notice that town also an inspection team paid duty to my urban area, and obtain feedback from the beneficiaries. I have no knowledge, I have nothing, they didn't turn up to my shop. Then kindly turn to page 36. They have visited the alleged houses of the beneficiaries. Then each and every 12 allegation I have dealt with in page 36 by giving the name and supporting documents. Supporting documents means well not uploaded from the equal question.
Yes.
Page 36 will also kindly come. First paragraph, fourth paragraph. I say that so far the consumer, namely Inspector Follow is concerned. 95 I say that the Interim received 45 pages of wheat by using the mode of Aadhaar authentication through report machine, which is recorded in the report machine, and copy of the report stick enclosed. I have enclosed. Then kindly, after two paragraphs, I say that so far consumer name Shahir Ali is concerned. Have you also got my lot after two paragraphs?
Yes.
Same thing I have given all documents I have enclosed. It starts from my lot page 33 up to my lot page kindly transfer page.
No, what is the allegation?
Allegation
That
is
you have given less
lesser quantum.
lesser quantum.
Quantum.
But
And
you are saying that EPOS machine showing that
I have annexed the slips uploaded from the EPOS machine that these quantum has been given to them. This is also disclosed in the office headquarter also. That's the system. If I don't give, that has not been relied upon. If I give lesser quantum, that will also be displayed in the headquarter also. This is my case. I have given and enclosed all the documents. If you also kindly turn to the document which I have annexed with my reply, it starts from page 42.
Yes.
All 12 documents I have annexed. All 12 documents. Then you also kindly turn to the order of termination. At page my lord. Page 68. 23 pages reply. Page 67 is the proceedings. In kindly see, minutes have been enclosed. Apnar naam ki page 67.
Yes.
আপনি সেক্রেটারি হিসেবে থাকার কোনো প্রমাণ আছে? কোনো প্রমাণ বর্তমানে পরে দেখিয়ে দেবো। আপনি জানুয়ারি মাসে এবং তার আগের মাসে গ্রাহকদের বলতে কম দেন কেন? আমি কম দিচ্ছি না। যে প্রাপকদের কম দেন বলে অভিযোগ করেছেন সে ব্যাপারে আপনি কি বলতে চান? অভিযোগ সমস্ত মিথ্যা। আপনার কি এর বাইরে কিছু বলার আছে? আমার যদি পেনরোল ভুল হয়ে থাকে তার জন্য আমি ক্ষমা চাইছি। Then my lord, order of termination, page 60. After so many things, kindly say just 3 lines. Just your lordship, kindly take note of this. 32 pages reply along with 70 to 12 documents enclosed therewith. This is the only reason. Kindly see last paragraph. No reason. Not a single statement of my reply has been dealt with.
No, last but one paragraph. Where is the
reply to the answer is not satisfied? Why? There is a permission for appeal. How can I prefer an appeal? Unless the reason is disclosed by the original authority. No satisfaction. Why? No reason at all. Your lordship knows there is a cantina of judgment. The reason is the heart of the decision. I have brought those judgment also. Nothing. I have enclosed all the documents along with my reply. Then, my lord, kindly see, my lord, first appellate authority, page 69, it starts from page 69 up to 75. Page 75. Ground, your lordship, kindly come, page 75. Ground for challenge. Kindly turn to page 76, ground number B. From a perusal of the order of penalty punishment, it would be apparent that the same is non-speaking, unreasoned, and cryptic one, and no prudent man can understand on perusal of such order as to which manner reasoning officer so and so concluded that the charges leveled against me have been proved. C. Being the licensing authority who has acted as a quasi-judicial authority should have come to decision independently and impartially, but from the recording of the order dated so and so, it does not appear that the licensing authority acted independently or so and so. All this ground have taken. No.
Your Lordship, in this matter, Your Lordship, we have not yet received the factual instructions from the department, Your Lordship. The matter, Your Lordship, Your Lordship, I have not received the instructions. Your Lordship kindly gives us a week's time.
No. In that case, my lord,
Your Lordship will Your Lordship, this is a matter including disputed facts and law as well, including a major dispute in fact, Your Lordship. The documents only pertaining to the petitioner has been annexed here to Your Lordship. The documents pertaining to the department's procedures need to be also considered, Your Lordship. Your Lordship, but the departmental instructions have not been received, Your Lordship. We have received the brief recently. Your Lordship kindly gives us a week's time. Any day, Your Lordship will keep it any day, Your Lordship.
20th November, they have received it.
Your Lordship, Your Lordship, there is a procedure of assignment of briefs, Your Lordship. Your Lordship,
that takes less than 48 hours under the rule.
Your Lordship, I leave it to Your Lordship.
I'm only praying before Your Lordship not to declare any vacancy. Nothing.
Your Lordship will kindly
whether you are in a position to declare vacancy?
I have no instruction regarding that. As on date, I have no instruction that we have
the order of termination was passed. 23.
Your Lordship, final.
Appeal. Kindly see the second appellate authority order.
Your Lordship, 23 till date, perhaps no vacancy has been declared.
Record it.
I have no instruction. How can I record? How can I get it recorded?
Just protect the first status quo for a
Your Lordship, that cannot be done without hearing the respondents, without instruction, Your Lordship. Only hearing the petitioner, an order cannot be passed, protecting them.
Back, I have served it.
It's not a private. It's not a private respondent they are serving.
Come on, 5th then.
Your Lordship, 5th and 6th, I am not in Calcutta, Your Lordship. Any day, keeps it on Monday, Your Lordship, takes it up, takes back.
In the meantime, not to
I cannot take any undertaking without the instruction of the department. I am appearing for the state and not the private respondent.
Okay, if the declaration is there, I will pass the order of stay. No issue. Come on, 9th. 9th.
Your Lordship.
Okay.
Your Lordship. Sorry.
Please come.
Sorry, sir.
To be mentioned, my lord, item number 1. Otherwise, my lord, there is every possibility of declaration of it.
Learned counsel appearing on behalf of the petitioner submits that the petitioner has demonstrated a case before this court that the natural justice has been violated in dealing. The principle of natural justice has been violated by the authority concerned in dealing with the procedure for termination of license of the petitioner. He paid for necessary order of stay so that no new vacancy may be declared in the cited location. Learned counsel appearing on behalf of the state state respondent seeks accommodation to demonstrate the matter with some instruction of the department. And the next week, let the matter appear in the list on 9th of November under the heading of to be mentioned at 10:30 p.m. Affidavit of service filed on behalf of the petitioner is taken on. But again, yes.
Your Lordship, few order has been passed on 28th and 27th, Your Lordship. Still now it hasn't been served, Your Lordship. Kindly direct it to be uploaded on the server.
28 যেটা বলেছিল আপলোড হয়নি? হ্যাঁ, সব সই হয়ে গেছে। কি বলছেন কি? সব সই হয়ে গেছে। 8টা পর্যন্ত থেকে সই করে দিয়ে যায় সব। তারপরে এরকম বলছে কেন সব এরা? Give me the list. Give me the list. I'll check. লিস্টটা নিন আমার কাছে।
দিয়েছি না?
Okay.
Thank you. Grateful, Your Lordship. Much obliged.